All set, Mr. Chair.
Thank you very much, Erica. Good morning. Recognizing a quorum, I am calling this meeting of the Cannabis Control Commission to order at 10 a.m. on June 19th, 2020. I want to alert the public this meeting is being recorded. I want to welcome everybody listening in remotely. I hope that you and your families are all safe and healthy. As this meeting is being conducted remotely, all votes taken by the Commission will be done by roll call. I truly do not know how long this meeting is going to take. We have a lot of material to cover. We have a hard stop at 5 p.m., but we do have a spillover date next week if we're unable to get through the entire agenda by then. We will certainly take some breaks along the way, but I anticipate a pretty long meeting today. Before I get onto the agenda, I would like to make a statement. I want to acknowledge that our 2020 regulatory policy discussion begins today on Juneteenth, a national celebration of emancipation, but also a recognition of how much more work needs to be done for this country to truly reach equality and justice. It seems apt that many of our discussions today will focus on expanding, modifying, and tweaking our regulations to ensure that we are doing everything possible to meet the equity and social justice mandates of our enabling legislation, specifically fostering full participation in this industry by those who were disproportionately harmed by prohibition. I encourage all who are watching today to keep holding us accountable as we continue listening, learning, and acting on our commitment to create an equitable industry in Massachusetts. Thank you. Before I move on to the agenda, may I ask my fellow commissioners, anybody else would like to make an opening comment? I certainly welcome that. Okay, can we move on then to the agenda, please, Erica? Thank you. We are not going to conduct any normal commission business today, with one exception. We have a meeting scheduled, our regular monthly meeting scheduled on July 9th, at which point we'll go through the normal commission business, including an executive director's report and processing a large number, as we have over the last couple of months, of license applications. The one exception to the agenda today is that we will consider one provisional license. This is a license that was not on our June agenda because we hadn't received, we believed, all the necessary information. It turns out that the information that we were missing had been misplaced by us, and for that I apologize. We strive to be a zero defect organization and work very hard towards that objective. When we do make a mistake, we apologize and try to rectify it. In this case, it seemed like the fairest thing to do was to, when we realized our mistake, to put it on the agenda for this meeting. So we will have one provisional license to discuss this meeting, and then we'll get into the regulatory policy discussion. When we get into that agenda item, the regulatory policy discussion, I'll give context about the process and where we are in the process and what's going to happen next. But let me wait until we get to that point in the agenda, and let's move into the first agenda item, which is provisional licensure. Mr. Potvin, I don't see your smiling face. Are you on the phone or on the line?
Yes, sir.
How are you?
I'm well. How are you, sir?
I'm well as well. This is going to be by our normal standards, it's going to be a pretty easy day for you, huh? Just one to do.
Just one. I'm not going to even need to take a break.
Okay. Well, you can start then. The provisional license to be considered is Hidden Hemlock LLC, MBN 281-355, which is a micro business. Mr. Potvin.
Thank you, Mr. Chairman. As you stated, the applicant here is Hidden Hemlock LLC. The proposed location is 370 Wareham Street, located in Middleborough. They are applying to be a micro business licensee to perform cultivation and product manufacturing operations. As noted, the applicant is not an applicant or licensee for any other license type. It was an expedited applicant due to the fact that they are applying for the micro business license. There's additional information contained within the executive summary for the Commission's review and consideration. With that said, Commission staff do recommend the issuance of a provisional license subject to the conditions before you.
Thank you very much, Mr. Potvin. I do have one proposed condition from Commissioner Title. I'll read it. Revised diversity plan goal to hire at least 10% of staff who are women, who are minorities, women, veterans, and other groups to be objectively reasonable. Besides that request for an additional condition, are there any other comments or questions from any of the commissioners? And Commissioner Tuttle, I got that condition correct. I read it correctly. Is that true?
Yes, thank you.
Sure. Okay, then could I ask please for a motion to approve the staff recommendation on Hidden Hemlock LLC MBN 281355 micro business subject to the additional condition requested by Commissioner Tuttle. Commissioner Tuttle, would you make such a motion, please?
So moved.
Thank you. Commissioner McBride, would you second that motion, please? Oh, get off mute, please.
Sorry. Second.
Thank you. Let the record show that Commissioner Tuttle made the motion to approve, seconded by Commissioner McBride. Commissioner Flanagan, your vote.
Aye.
Commissioner McBride.
Aye.
Commissioner Tuttle.
Aye.
Commissioner Hoffman, aye. Let the record show that the commission unanimously approved the staff recommendation to issue a provisional license to Hidden Hemlock LLC. Thank you very much. And again, my apologies that this was not on the June agenda. Mr. Potvin, any other business on your end right now?
Not at this time, sir.
Okay, well, we'll make up for your short work day today by piling on the 9th. Thank you very much. Let's go ahead to the next agenda item, please, Erica. Thank you. So as I mentioned, the only other agenda item is to have a policy conversation on a number of regulatory changes that are being contemplated by the commission. Let me give some context here. From the first round of regulations that we promulgated in March of 2018, we have said that our intent is to observe how the industry evolves, to listen, to learn, and to adapt as necessary. We have certainly tried to find the balance between making those adjustments as we see how the industry evolved, but not changing things so quickly that the industry does not have a chance to adapt and adjust. But we do feel that it is important. That we continue to make changes, and we're in the process of doing that right now. The last round of regulatory changes was finalized in September of 2019. At that point, we said let's take a little bit of a pause, give our staff a chance to catch their breath, give the industry a chance to adapt to the new regulations. But we recognized that we had more work to do, and so in October of 2019, we put together a list of topics that we felt needed to be addressed in our next round of regulations. We set a timeline where we'd start working on that in early 2020. And I made a commitment to Commissioners Doyle and Tuttle that we would try to finish that before the end of their terms, not knowing whether they would stay for a second term or not. And that commitment still exists to try to get this done by the end of August. We have a lot of work to do, but the way we've gone about that is that we created 5 teams, each led by an individual commissioner and with 3 or 4 staff members from our licensing, our legal team, our enforcement team, and other parts of the organization. And we assigned topics based upon the list of topics that we created in October of last year. We assigned topics to each of those teams. And each of those teams have been working pretty regularly over the last, let's say, 4 or 5 months, fleshing out the topics they were assigned, coming up with options to consider in terms of changes, and in some cases actually drafting draft regulations on those topics. But for some of the topics, the individual commissioners and their teams believe that before going too far down the road and finalizing draft regulations, that a discussion at the commission level was necessary to give some guidance and direction. And so there are 17 topics that are on the agenda today that have been raised by one of the writing teams for commission discussion and resolution. I would subdivide that list of 17 topics into 2 different groups. There's a set that I would call temperature checks. They're important decisions, but they're kind of yes or no. Does the commission wish to do this, or does the commission not wish to do that? And the teams, again, requested that we publicly discuss that before they went too far down the road drafting regulations. And so first 9 topics are what I would describe as temperature checks. The next 8 topics are what I would describe as more full-throated policy discussions, where there are complex issues that have important ramifications on the industry, and that, again, the teams that were working on these issues wanted a full discussion and a vote by the commission on these policies before they went further. And so the second set of topics will be those full-throated policy discussions. To get ready for today, just was an enormous amount of work, not just by the writing teams, but by all of our staff. And I wanted to thank the staff that helped get us to this point, and will continue working with us as we get to a finalized set of regulations. I particularly wanted to call out, though, Pauline Wynn, our Deputy General Counsel, who had the unenviable assignment of trying to coordinate across all 5 of these teams, and has, in my opinion, done a truly remarkable job on that. And so Pauline, the entire staff that's been involved with this, I want to thank, but specifically Pauline, thank you very much for your involvement and your leadership in this. Going forward, I just want to make a few other comments about how the rest of the process will play out. One thing I want to highlight is that these 17 topics that we're going to discuss today do not, they're not all the topics that will be part of this regulatory round. There are a number of other topics that were identified back in October that the teams are working on that they felt like they didn't need inclusion in this list of policy conversations today, but will be part of the draft regulations that we will discuss and vote on in public in early July. So if you don't see a topic that you thought was going to be part of this round, again, this is not the complete list of topics that will be addressed in this current regulatory round. And all those topics, including the ones today, but including the ones that are not discussed today, will be discussed and voted on in a public meeting in July. Right now, we don't have a specific date for that meeting where we will discuss and vote on all of the draft changes to our regulations. We're going to convene. The team has been working on this. Will convene early next week, and we'll see how much work we have based upon what comes out of today's meeting, and we'll set a date, whether it's going to be part of our normal publicly or previously scheduled meeting on July 9th, or whether we have a subsequent meeting the following week. We'll figure out and we'll communicate quickly. Once we're done with the discussion and vote on the draft regulations, we'll follow the same process that we have in the past, which is we'll promulgate those draft regulations. As soon as they're promulgated, we will schedule a set of public hearings and a public comment period in the second half of July and early August. We will meet again, hopefully by the end of August, as I committed, to discuss any changes that we will make to our draft regulations based upon the feedback that we got in the public hearings and the public comment period, and we'll vote on final regs. For those of you on the call remotely, I urge you to participate in the public comment period and or the public hearings. If you look at our past history, we have made substantive changes to our draft regulations based upon the feedback and the input we got from the public during these hearings and during the public comment period. So please participate in one or both of them. We will have more info hopefully by next week on the timing and logistics for the public comment period and for the public hearings. Finally, I just want to set expectations. This is our 4th round of regulatory adjustment. It is my intent to take a break and give, as I said, the staff a chance to catch their breath, but more importantly, the industry a chance to adjust to and adapt to whatever regulatory changes we make. So my intent and expectation is that it'll be about a year before we get into this again. Obviously, that can change if circumstances require, but I just wanted to set expectations that it'll be a while before we start this process again. We will continue to maintain a list of issues that will be addressed in the next round. Any comments or questions before we get going? Okay. We're going to go through each of these topics. The conversation will be led by either Pauline or a commissioner that was involved in the development of that topic, and I think, unfortunately for everybody, but particularly for myself, the first 5 of these topics are mine. So, came from my writing group. So I'm gonna start the conversation on the first 5 agenda items here, starting with leadership ratings. Could I get the next slide, please? Or the next, I'm sorry, the next slide, please, after this. Thank you. So I'm going to just go through what we think my writing team recommends on leadership ratings, and there's 4 topics here. The first is in the current criteria for Social Justice Leadership Award. I'll read it. It says 1% of the marijuana establishment's gross revenue is donated to the Social Equity Training and Technical Assistance Fund. There's a second requirement as well, but it's the first requirement that I wanted to address. The problem is that right now there is no Social Equity Training and Technical Assistance Fund. It requires legislative action, and that legislation is in process. But there's a concern that we have, and I think Commissioner Title raised as well, about how do you give out an award to somebody based upon a prospective action that they might be able to take based upon legislative action. So that's the concern we got there. Commissioner Title, could I put you on the spot and ask for your comments and suggestions about how we address this issue?
Yes, sorry. Thank you for asking for my comments. I would like to propose an alternative and then talk about the fund for a second, if that's okay.
Absolutely. Thank you.
So I think a good alternative might be for some licensees that have an exemplary diversity plan or positive impact plan that has been implemented to be a good criterion for this award. As for how they would be selected, we already have staff that does a great job reviewing both the plans and the documentation that's submitted with the renewals to make sure that it's sufficient. So they could potentially nominate exemplary plans upon renewal when looking at the documentation, or similarly, commissioners reviewing that documentation upon renewal could nominate them for this award. I could leave that up to your group since you've looked into how ratings should work, but that would be my alternative proposal for discussion. And then in terms of the fund, I just want to explain it a little bit more, especially because it is my fault. When we started, probably a couple months in to being regulators, the idea of this fund was that we would not be asking for any money or revenue to put into it, but rather voluntary donations that came from companies as part of their positive impact plan or another reason to go into this fund and would then be used for the restorative justice goals that are specifically mentioned in our enabling statute, specifically technical assistance and mentorship. However, that fund was not created. I want to thank Senator Jason Lewis for introducing a bill, which was Senate Bill 1708, but it was sent to study. So I think at this time I would call on all of us to continue to keep asking for that fund to be created, because it seems like a win-win if there's companies that want to make donations and there are, and we would be able to administer that for the purposes that are stated in the statute. But in the meantime, I think it would be good to consider alternatives so that we're not giving awards for prospective actions.
Thank you, Commissioner Eilert. So I think that's exactly the spirit that, for these first 8 temperature check items we should operate on, which is that the writing team that's responsible for the topic is looking for input and suggestions. We don't need to take votes. We'll take votes around the final draft regulations that embed the suggestions that are being made today. But my team and the other teams that have topics that are part of this temperature check are just looking for input. So I appreciate your input, Commissioner Title, Commissioners McBride or Flanagan. Any thoughts on this before we move on? Commissioner McBride?
So I just had a question because we don't currently have a process for how these leadership ratings are determined. I just heard Commissioner Title sort of propose one possible process with our staff or commissioners nominating. Have we given more thought to very specifically what that process would look like and whether there would be the ability for licensees themselves to sort of raise their own activities and kind of highlight them? And the reason I asked that is because I had a couple of other thoughts about how we could supplement these leadership ratings, but I think it really, in my mind, sort of requires for the licensee to be identifying for us that they are doing particular things.
Okay, I appreciate that. I'm gonna ask our executive director to respond, other than say that when we put these together, we said that we needed a year's worth of information, and so we're just literally getting to the point where I think it's appropriate to formalize the process that you just required. So I'll let the executive director kind of let us give us an update on where we are in terms of formalizing the process. Mr. Executive Director.
Sure, and good morning, everyone. Thank you, Mr. Chairman. There is no formal structure for an entity to apply or to identify themselves as being eligible or qualified for a leadership award. I guess what I would think a process that would make our internal processes a bit easier is if upon renewal they identified in their application which awards they believe they either should be eligible for, would be eligible for, or would like to be considered for, and then upon reviewing those materials, presenting to the commission a renewal, and then possibly designating them as whatever leadership award they might be eligible for, and allowing that consideration at that time, knowing that, to the chairman's point, it would be based on the previous year's information and data.
Thank you, Mr. Executive Director. Commissioner McBride.
So I had a couple of other thoughts for criteria for some of the existing leadership ratings, and then also a possible new category.
Are you going to steal my thunder? Because we have a possible new category as well, but I'll let you go first.
Oh, all right. So the first one that I had given some thought to was under the Social Justice Leadership Award. While I think that it's extraordinarily important that we are talking about contributions that will sort of pay it forward and actually, enable the technical assistance, I also think that there's an opportunity here to call out licensees who are engaged in activities that are actually, trying to make the difference that we talk about when we talk about social justice leadership. And so I was thinking about something along the lines of, or the licensee can show that a significant proportion of full-time employment positions are held by individuals with a past conviction for a marijuana-related offense. I think that is starting to kind of get at what we've been trying to build for the past several years about providing opportunities and sort of walking forward with there being, kind of something that's transformational going on here. So that's one thought that I would ask for the group to kind of consider, if that is, a possibility, or if there are similar types of things that we could highlight or criteria that we could highlight for licensees.
Okay. Well, I can, since this is my writing group, I can commit to considering that.
The second one is for local employment leader, which is right now not one of the categories. Actually, I'm sorry, it is one of the categories.
Excuse me, sorry for the interruption. Erica, if you go to the next slide, I think it actually is consistent with what Commissioner McBride is using. So if you could go to the next slide, please. Yeah, there we go. Go ahead, Commissioner McBride.
Yeah, so I think that I love this as a recommendation because the more that I've been out sort of talking to people, as I've been, one of the things that comes up is ancillary businesses, right? And so I think that if we could add a criteria of something like 51% or more of the contracts for ancillary services are with Massachusetts-based businesses. I think that that's a really nice way to highlight that we are, trying to be supportive, right, of the economy here in the state. And so I would kind of recommend that as something. And then the third one is adding a category for diversity employment leader. And that would be, in my mind, something that for licensees who can show that a supermajority of their workforce is made up of individuals who are veterans, disabled, minorities, LGBTQ, or women. We all know that all licensees should be diverse. We have diversity plans that seek to ensure that. But I think providing something that would really allow for licensees to highlight the efforts that they have made and really point to, what the effect is of those diversity plans would be a nice way to promote that as an activity.
Thank you, Commissioner McBride. I think that makes a ton of sense, but I'd love to hear comments from the other commissioners on that specific proposal that Commissioner McBride just made. Commissioner Title?
I think those are all great ideas. I would support all of them.
Great. Commissioner Flanagan, any comments?
I just have a general comment. I really think that, I've been saying for 3 years now to be good neighbors, be good business people, be part of your community, become fabric of wherever you are. And I think that by expanding the leadership ratings, we have an opportunity to do that. I would also like to hopefully get some feedback during the public comment period about community involvement and just having a company that goes above and beyond their positive impact plan to really make a difference in their community that they're in, and sort of work on the criteria that we could set for that. I think that community involvement is important. People get recognized for that all the time, and that would be something that we could have our entities aspire to be part of.
I think that's a great suggestion, Commissioner Flanagan. Thank you. So this is great input for the writing team that I'm involved in that's dealing with this topic. Can I just put one more issue on the table just to get some feedback from the commission? So when we did our initial round of regulations back in March of 2018 and created these leadership rating categories, we were at that point solely responsible for the adult use industry. When we took over the medical industry, which was at the end of I guess it was the end of 2018, if I remember correctly. These leadership, I believe, based upon the fact that we now have responsibility for the medical marijuana industry, that we should do two things. One is extend into the medical regulations these leadership ratings so that medical dispensaries and medical licensees can be considered for these leadership ratings. So that's one thing I would like input from the commission on. And two is the idea of creating and I want to be careful. I don't want to create so many categories that we're kind of demeaning or diminishing the impact of these categories. But our team had the idea of having another category of leadership ratings that would be specifically around leadership in terms of the medical industry, in terms of providing support to patients in the medical industry. And so I'd very much appreciate feedback from my fellow commissioners on those two things. One, should we add these leadership categories as they exist right now to the medical regulations? And two, should we create a separate category, an additional leadership rating category for the medical community or the medical marijuana part of the industry? Any thoughts? Commissioner McBride?
Yep. I completely support that. And I think that we have other aspects of what we're going to be discussing today, including things like the hardship program, where
Right.
I think that could be something that is pointed to as a marker for whether you are in fact showing leadership in this category. And so I completely support that.
Thank you very much. That's great input. Commissioner Flanagan, or title?
I support it. I think that, even for the medical program, there's a way to create a leadership program specific to their work with patients.
Right.
If that's what we want to do as well, because I think that patients are a very specific cohort of people, and whether they're being educated or, you know, they're really helping them with something. I think that maybe we can even consider something like that.
Thank you very much, Commissioner Flanagan. Commissioner Title?
I agree. Could I just ask you to repeat something? I didn't fully catch the difference between the two things you raised. One was these being applicable to medical as well, and then what was the second one?
So there's two things. One is take all the leadership categories that we have currently and embed them in the medical regulations, so that, you know, the MTCs can be considered and applied for and appropriately rewarded with these leadership ratings. So that's one. The second is to add a new leadership category. And I think Commissioner Flanagan was quite articulate about leadership as it relates to how they take care of patients. Commissioner McBride's point was to also talk about hardship and how they contributed to that. And so one is to just take our existing categories and apply them to the medical regs. The second is to add a new category of for leadership rating.
Got it. Thank you. I would support both of those, and I agree with Commissioner Flanagan for what the second for an individual award just for how you treat patients, and it would be great if we could consider the hardship program in that specifically.
I think we got that direct guidance from Commissioners McBride and Flanagan, so that's certainly the intent of the group. That will be the intent of the group. So thank you. I see that the Executive Director has put his camera on. Would you like to say something, Mr. Executive Director?
If you wouldn't mind.
Go ahead. Of course, I never mind listening to you.
And thanks for indulging me. I think in building out these different criteria and consideration for different awards, one thing to keep in mind is the ease and the ability of the commission, including the staff, to make these evaluations and when they actually occur. And so in thinking about how we would implement it, I think it would ultimately include, again, as I mentioned earlier, the submission upon renewal, the renewal application itself, indicating a desire to be considered for these awards. And that would then, I would imagine, open up a ability to upload documentation and other materials that would allow for us to make that consideration. My fear is if there's a lot of criteria, it becomes sort of an investigation.
Sure.
And wanting to make sure we're able to quickly consider these and make sure that we're able to do it with data that we may already have or data that could be easily supplied by licensees.
So thank you very much, Mr. Executive Director. I'll ask you after the meeting, as my group, my writing team takes on the recommendations and suggestions that came out of today's meeting, I'll ask you whom to collaborate with from the staff to make sure that we're addressing the concerns that you just raised. Any other comments on leadership ratings? My intent, and push back please if you feel otherwise, my intent is that not to take a vote on this. This is meant to be guidance for the writing teams and input to the writing teams. The actual draft regulations that will contain the guidance and suggestions that are made today will be discussed and voted on in public at our next meeting. So I don't feel it's necessary to take a vote on this. This is intended to just, because of the open meeting law, make sure that as the writing teams finish up their work, we're getting input from all the commissioners. Can I ask our General Counsel, Christine Bailey, do you agree with that? That we on these temperature checks, we really don't need to take a vote?
I think that's right, that this is really policy discussion. So you're basically identifying issues for the staff and potentially others to address in terms of further drafting. Okay,
well, so thank you. And again, I just want to emphasize these will be discussed and voted on in public when we consider the full set of draft regulations and the changes. So we will have an opportunity to have a vote at that point in time. Okay, unless there's anything else on leadership ratings, let's move on to category 2 or topic 2. This again came from my writing group. I'm going to just summarize it at a high level. I'm happy to take questions. And this is something that a number of people in the industry have raised. Right now, any change of control, we have a well-defined process of evaluation. We have criteria for evaluation. Ultimately, the staff, as it does for all licensed categories, makes a recommendation that we discuss and vote on at the commission level. And I think that process actually works well. the issue on the table that our team has been wrestling with is that in the case of financial distress, our process takes a long time. Because of the federal illegality of marijuana, their companies that have financial distress are not eligible to go through the bankruptcy process. And so the process is a state process where a receiver is appointed to conduct an orderly either disposal of the business or reorganization of the business to allow it to continue to operate. By our criteria, a receiver would represent a change of control. And my concern and the concern of our writing team is that our current process, which as I said, I think is very thorough and appropriate, probably can't move quickly enough in the case of a receivership where a company is in severe financial distress. We have looked at other states and how they have dealt with this process, and at least from our analysis, it looks like Washington, the state of Washington, might represent best practice here. And essentially where we're proposing to go, pending the input of my fellow commissioners on this, is to recommend that we have a process where people can be pre-approved by the commission to serve as receivers. And if they are pre-approved by the commission to serve as receivers, that we delegate to the executive director the authority to approve the appointment of those receivers, again, with the sole notion being we need to move, I believe, more quickly than our current process would allow us to do in the case of financial distress. So there are a few other parts to this proposal, but I wanted to just stop there and get input and response to that particular proposal. Any comments, Commissioner McBride? Looks like you're about to raise your hand.
Yeah, so I think it makes sense to have a list of receivers. That's something that there are actually analogous processes in other parts of government where receivership programs exist, and so I think it makes sense to sort of have the approved list. Have we given thought? I mean, I'm in thinking about the issue of control.
Yes.
So the receiver is going to have a fiduciary duty, right, to act in the best interest of the licensee, right, and to act in the best interest and balance, right, what the obligation is of safeguarding, right, that property and specifically making sure that there's no wasting. I guess I'm not sure about how control would play into that, given the presumably temporary nature of the relationship.
I'm not sure I'm completely following. One of the things that we have thought about is that the receiver would, for whatever period of time they had that the fiduciary responsibility, would effectively have control. And the appointment of a receiver to guide a company through this process would have to be subject to the overall cap limits that we have on any individual or entity in terms of the number of entities they can control. So we would ensure that a receiver, if appointed, would not violate those cap limits. But I'm not sure that exactly was the question you were asking.
Okay. I guess, I mean, I'd like to sort of see how it ends up getting spelled out. I guess I'm not as I'll look forward to kind of seeing how it ends up getting spelled out in the regulations, because sure. I'm not exactly sure how what the level of concern should be around the control issue, given the temporary nature of the relationship. Hopefully. Yes.
No, fair enough, Commissioner McBride. Sorry, I'm sorry, I didn't mean to interrupt. Go ahead.
No, the other piece of it is, so typically with receiverships, I mean, you do need to get court approval for it. Has there been conversation around sort of what that process might look like?
Yeah, I mean, it has to be a parallel parallel process of the court approving a receiver and us approving the receiver in the context of our regulations. So we have given some thought to that. I agree with your point, by the way. This I think is something that you really need to see the detail of the proposed regulations to get comfort with it. And just as a side note, after we finish today and in preparation for our next discussion, when we actually go through the draft regulations and discuss and vote on them, we'll give each commissioner as much lead time as possible, because a lot of these conversations, in theory are relatively straightforward, but really it comes down to what the language looks like. So I understand your point.
Thank you.
Sure. Commissioner Title or Commissioner Flanagan? Again, I'm just asking for some directional guidance. If anybody's uncomfortable with the direction that we're heading on this, I certainly welcome feedback.
I'm not uncomfortable with it. I don't have any additional comments, though.
Okay, thank you, Commissioner Flanagan. Commissioner Title?
Same. I have some questions about what the pre-approval would entail and why we necessarily need a pre-approval, but I'd be fine with just looking at the draft.
Yeah, so the draft will give some more detail about what the process would look like. The reason I think we need pre-approval is from a perspective of speed. Just again, and by the way, just I was asked this question recently. There are no licensees currently that I am aware of that this is relevant to. This is meant to be proactive and anticipatory, but I don't want anybody to listen to this conversation and draw the conclusion that we have entities that are in financial distress. I am not aware of any that is the case, but like any industry, it's unfortunately part of the process. So it's likely to happen somewhere down the road. This is a requirement, but the notion and the reason for the pre-approval, Commissioner Title, is again to allow us to move as quickly as we can in that circumstance. But we'll provide all the detail, and obviously it'll be part of our discussion and vote when we get to the draft regulations. If we go to the next slide, please, Commissioner or Erica. Thank you. We debated making any changes to our definition of control and ownership. We decided not to, at least as a group, but again, I welcome input and suggestions. And the primary reason that we chose not to recommend any changes is that we made some pretty substantive changes in our last round of regulatory development back in the fall of 2019. Unfortunate, this is going to sound immodest. I think we actually made substantial improvements in bringing specificity and clarity to our definition of control in that last round. And I just feel that it's something that we should probably let settle in for a while before we make subsequent changes. And so the group has not recommended any changes other than trying to bring specificity to one topic, which is what qualifies as, quote, a significant contract. And we thought we just used the same criteria we use internally for our agency, which is any contract that exceeds $10,000. But otherwise, the group is recommending that we make no change to the control and ownership definitions. Any comments or concerns about that?
So oh, sorry.
Go ahead. Yeah, go ahead, Commissioner. No, go ahead, Commissioner McBride.
So I was wondering how we landed on the amount of $10,000 as a significant contract.
I'll have to go back and and go through my notes. I actually think it's what we use internally, but as a threshold for what can be approved without commission approval. But I'm not sure that anything I say is going to be other than semi-arbitrary. If you have some thoughts on that, I'd welcome them, Commissioner McBride.
No, I'd like to hear a little bit more about that number, because to me it feels a little bit low, but
okay.
But I'd like to hear more about that.
Thought and try to come up with some best practices in other areas. So I appreciate the input, and we'll work on that.
And I also would just add that I think option B, with the delegating the approvals to the executive director, I think that does help to expedite matters. And so I would right now, without sort of seeing more,
sure.
I think that is a good option.
Thank you. I appreciate it. I hadn't actually gotten into that yet, but thank you for introducing the topic. But I appreciate what you said. That's certainly the intention and the objective of our writing group, was to try to, in cases that were below some threshold, make it easier for the staff, make it easier for the executive director, make it easier for the commission, and make it easier for the industry to approve changes. So what you can read, but we discussed a set of changes, licensing actions that we thought we could delegate comfortably to the executive director, including changes to the location, new equity owners as long as they stay below the 10% threshold, new executives or directors, again, assuming their personal equity stays below the threshold, and then reorganizations that ownership and equity does not change, but they're just more legal reorganizations, and then the topic we just discussed, which is receiverships. So I'd like comments if anybody's concerned with the direction that we're heading on this particular issue of delegating some of the approvals for changes of control to the executive director, including if the executive director doesn't want this responsibility. No, I'm kidding. I think. Commissioner Title?
Just a couple of comments. If these are delegated, could we make sure that all of the changes are published with meeting material so that we and the public can review them?
Of course.
And then also regarding 2 and maybe 3 for a new equity owner, if a owner is already an owner and they are changing their percentage, this wouldn't apply to that, correct?
The way we're currently drafting it, that's correct. I mean, we can change if you have suggestion. We're happy to reconsider things.
No, that's good. That's good. I was just making sure because I wouldn't want someone to go from 45 to 55%.
Sure. No, I understand your point, and that will be reflected in our proposed language.
Thank you. Also, as far as $10,000 go, it makes sense to me. I've seen that standard before. I would just want to make sure that when we specify that, we also make sure that you can't divide a larger transaction into multiple $9,999.
That makes sense. Thank you.
All right. Thank you.
Commissioner Flanagan, any input on this? Are you comfortable with our direction?
I'm comfortable.
Thank you very much. Okay, let's go to topic 4, please. Okay, right now the social equity program has a set of criteria that have to do with disproportionate impact of prohibition, arrest, and so forth. There has been a request for our group to consider whether we should expand social equity program participation to include other categories, such as veterans. We can write a draft. Our team can easily write draft regulations here, but the question is, what should those draft regulations reflect? And as we thought about it, there were 3 possible outcomes that we wanted commission input on before we proposed draft regulations. One is just leave it as it is currently. Second is to specifically include veterans as a group eligible to participate in the social equity program. Third is to not take any immediate action, but to allow the commission by vote to expand the categories at any point in time in this judgment without having to go through a subsequent change in regulations. So those are the 3 options. My personal opinion, and it's just my personal opinion, is that in the short term, I think no change is appropriate. I do want to make sure that we're doing everything we can to support veterans and other groups, but I think it's early in the evolution of the social equity program, and I want to make sure, or at least my opinion is that we need to keep it focused. But I'm very open-minded about this, and I really do want to solicit the input of my fellow commissioners before my writing team puts pen to paper, to use an old-fashioned metaphor. Any comments on this?
Mr. Chairman.
Yes, Commissioner Flanagan.
Thank you, Mr. Chairman. So I have conflicting opinions about this. I think first and foremost, the commission was created to ensure that obviously question 4 was upheld, and a lot of question 4 was a social equity piece of this. Having said that, I think that we focus specifically on a couple of different areas of what that inequity is. And I don't think that broadly we have looked at the entire state, because inequity is different throughout the state. Mm-hmm. And so I really want to allow the disproportionately impacted study that is being conducted as we speak to play out and to get the data back from that study, right. Because it's not going to solely be judged on arrest records. Yep. You know, I've said a couple of times, my problem with the last impact study that we had done was you have these arrest records and you've got these communities like Mansfield, who has an Xfinity Center with, you know, a number of concerts in their concert season. Obviously their arrests go up. Doesn't necessarily mean that they're a disproportionately impacted area. While we don't have many in the western part of the state, where disproportionately impacted could mean poverty levels. It could mean a whole host of other things. So I like, before we expand to any specific group, to keep it open-ended to see what this study shows. Because, you know, we obviously have the data coming in and is going to be assessed. That might give us a better landscape of what the entire Commonwealth looks like.
Thank you, Commissioner Flanagan. I don't mean to put words in your mouth, but given what you just said, would you support C here, which is that?
I do. I absolutely support C, and that's not to sort of push aside option B when it talks specifically about veterans. I obviously think that it's important to include veterans in our conversation. You know, veterans have some really technical training that they've been given, you know, while they were in the military, when they've been out of the military. If you take a look at the veterans that are, you know, that have recently come home or are coming home, that are looking to get into the industry, certainly they add a worth to this industry, given their knowledge. But I don't think we can talk about one category without talking about others.
Okay, thank you very much. Commissioners Teitel or McBride, any comments? Commissioner McBride, Teitel?
I largely agree. I would be fine with C, with some restrictions though. I think that we were actually very explicit about it in the beginning, that our first study was not in depth and it was done quickly, and that we always intended to do further studies. And being in that process now, I think it makes sense to allow the commission to use that data to determine if there are other groups that have been disproportionately impacted. And there will probably be more in the future. You know, there's other groups that have asked to be considered. One thing that was raised recently was our first study didn't consider deportations when we talked about disproportionate impact. So there's a lot of reasons why we should continue to study this and continuously update it. My only restriction that I would ask for, though, is if we do amend, as in C, that we make sure that any of the changes are based on data showing groups that are disproportionately impacted, rather than just expanding willy-nilly. Because I do think down the line we do want to expand the equity program more, and particularly when the legislature updated question 4, they added the provisions about women and people of color and veterans, which I think is a very positive change. And I think we do eventually want to expand to those groups. But I would agree with you, Mr. Chairman, that we're very early on. We've only had one cohort. So, and that would expand the program significantly if we opened it to all of those groups. So I think we should allow changes for disproportionately impacted groups for now. And then as we have more cohorts and more research on the equity program, then think about expanding it more significantly.
So again, not meaning to put words in your mouth, Commissioner Teitel, but that would be C with the caveat that you raised. Is that correct?
Yes.
Thank you. Commissioner McBride?
I'm supportive of option C.
Okay, great. Thank you. Okay, let's move on to topic 5. So again, this is just an easy thing to draft, as long as we're aligned on what we're trying to accomplish. So right now, there's a separate process for applying as to get an economic empowerment status. from getting into the social equity program. The proposal here is to actually allow one of the equity holders who collectively qualify for economic empowerment to essentially give them automatic entry into the social equity program if they meet the criteria that you can see here. And the logic is that, while economic empowerment applicants get some great benefits in terms of priority review of their applications and either elimination or reduction in fees, that the technical assistance and the mentoring and the networking that come out of the social equity program is an important contribution to their ultimate success. So this would be a pretty simple change to our regulations, which would, essentially automate something there. Now, there are a lot of economic empowerment applicants who are in the social equity program, but it's right now a separate process, and this would kind of just make it a little bit more seamless. Any comments or thoughts on that? Commissioner Tuttle?
I'm supportive of this, and this goes for many of the upcoming topics. I want to thank you and your group for your leadership in looking into really complex issues.
Well, we haven't begun to get into the complicated stuff, so go ahead.
That's why I said this applies to a lot of topics. But I also want to thank the economic empowerment applicants who have come to our forums and have otherwise made it clear that there is a need for technical assistance. I think this is an evolution from what the law originally envisioned in terms of groups that were ready to go, and could take advantage of priority review versus what we're seeing in reality. And this would fill that gap where there is a need for technical assistance. I'm also grateful that our staff is looking into informal partnerships with law school clinics, perhaps, and other ways that we can find technical assistance. I think this is a great step towards that too.
Thank you. Commissioner Flanagan and McBride, any comments? Are you comfortable with this direction?
Yes, absolutely.
Thank you.
Yeah.
Great. Thank you very much. Let's move on to topic 6. And I think I'm off the hook here. So I think this topic is going to be led by our Deputy General Counsel, Pauline Nguyen. If you are you there, Pauline? And can Erica, you put her on camera?
I'm here.
Oh, that's right.
So
You're going to stay off camera because we have better better audio when you're off camera. Is that correct?
Yeah. If it's I think it's going to be choppy with my camera on, so I'm going to turn it off. So.
Okay.
Okay.
Bye, Pauline.
So thanks, Chairman. So commissioners, before you are recommendations related to the ME and MTC agent registration process. To provide you with some context, under the current agent registration process, the entity or licensee is responsible for applying for the registration for its agents, including paying any registration fees. This means that if an agent works at more than one facility, the agent must be registered at each facility and carry multiple badges for each license a company has. The writing group was tasked with looking at the overall agent registration process, and in particular, looking into ways to streamline this multiple registration process for an agent. So in looking at this, the group considered what they're calling a free agent model, where the registration runs with the individual agent instead of the licensee. And under that model, the individual is responsible for registering themselves, paying for background check and registration fee themselves. The group decided not to recommend this free agent model for various reasons, including they felt that linking the registration to the license instead of the individual may make licensees take oversight of their agents more seriously, and that many of the licensees' diversity and positive impact plans include hiring agents from certain target communities, and so passing that the registration related fees and the administrative burden onto those agents would counter those efforts. The group instead is proposing to continue requiring licensees to register and pay the fees for their agents, but after the first year to require renewal every 3 years instead of every year to relieve some of the administrative burden on licensees. The group is also recommending an increase in the registration and renewal fees for ME and lab agents by $15 to cover the cost of producing the badges. It should be noted that the staff is currently in the preliminary phase and starting discussions about the feasibility of having a single agent card capture the multiple registration information for an agent and looking at what our options are, including the fiscal implications. However, pending the outcome of our efforts, the group recommends making no change to the regulations on this issue until the viability of a technical solution and the financial implications are assessed. Finally, the group recommends amending the medical use regulations to make the MTC registration process align with the adult side. Most of these changes just involve rearranging the provisions so that the numbers align on both sides for easy referencing. So the group is asking for feedback from the commissioners on the general direction the group is taking on its recommendations.
Thank you very much, Pauline. Can I have comments from the commissioners on the recommendations out of this group?
Mr. Chairman.
And again, go ahead.
So, Mr. Chairman, this was the writing group that I actually was a part of, and the conversation becomes, you know, how do we try to make this a little bit easier, but at the same time ensuring that we have all the information and that the information is up to date for each registered agent. You know, as Pauline had said, we looked at the free agent system where the person themselves would be responsible for updating and obtaining their agent card. But at the same time, we realized that with the diversity plans, a lot of people may not be able to afford their agent registration and therefore would preclude them from being part of the industry. And we didn't want to do that. At the same time, we know that, you know, it's cumbersome. If you work for a company that has multiple facilities and you work in more than one facility, you're carrying more than one badge. And so we're hoping that with any technological advances that are made, we'll be able to eventually have one badge that can cross-reference all the information across the number of physical entities that may be owned by the same company. If any of us, I mean, we've all been in these facilities where some people have, you know, 4 and 5 badges hanging from their waist. It gets a little bit cumbersome for them. At the same time, when we looked at the re-registrations or the renewals, you know, we thought that every 3 years instead of every year. And that way, you know, their Corey checks would be up to date, all the information would be up to date, and it wouldn't necessarily be every 12 months that they're going through this process for every one of the employees and the lab agents. So we're interested to get feedback from the commissioners, also from the public on what they think about the recommendations that have been put forth by our writing committee.
Thank you, Commissioner Flanagan. Commissioner McBride, title, any comments?
Are there other jurisdictions that do it in this way, so that there's a 3-year flag, or are there other jurisdictions that don't do it annually?
Commissioner Flanagan or Pauline, do we know that?
I don't know that. I would have to check with the group to see whether that was considered or looked into.
I don't know if we looked at other jurisdictions. We were more concerned with how long a Corey lasts. If we're constantly updating the Corey reports, would it necessarily be a year, and I think they found out, and legal can probably say, I think your Corey is good for 3 years.
Commissioner McBride, other questions or comments?
Then, yeah, I mean, that to me makes a difference, because I was going to ask sort of how the 3 years versus like a 2-year time frame was landed on. So I think that this is a productive way of easing the burden. Just obviously want to make sure that we're balancing, as I think the group has done, just balancing that we're, suitability is a continuing obligation, right? So just reflecting that is the case, while also, giving some breathing room in terms of expense and, need to be kind of constantly renewing agents.
Yeah, so we didn't look at other jurisdictions. We strictly sort of brainstormed our own and went through through this, how is viable for. At the same time, like you said, balance. There's pros and cons to both sides, right? There's a pro to the free agent registration system, whereas you have your registration card, you get to go wherever you want. But there's also the pro that if the marijuana establishment is registering all of their agents, then there's probably going to be a little bit more time and energy put into training and keeping them as part of their staff so that they don't have to constantly, update new agents. And so we tried to balance both of that to see what the better option is. And again, it's 6 of one, half dozen the other, I think. I mean, I would think a free registration system would help some people, but then I think it's going to keep others out of the industry, which is not what we're looking to do.
Thanks. Commissioner Tuttle, do you have any comments or questions?
No questions, and I agree with the direction that we're heading. I do have a comment in regards to what we do next time. I guess I think it makes sense to say that once we have a technical solution in place for a single badge, that it would make sense to make a change at that time. And then I completely see what the recommendation is saying in terms of a free agent model versus our current model and the pros and cons there. I think there could be a third option that would be more favorable from the social equity perspective. I think in the current situation, if you look at our statistics, our licensees are either unconsciously or consciously choosing to hire mostly white males. And what I used to hear from clients when I ran a recruiting firm and we used to talk about different background check rules in different states is that they would be hesitant to hire people that had a criminal background or that they suspected of having a criminal background because that would put them out money and time waiting on the background check and registration process. And so there's racism and that particular concern on top of ordinary racism. And so what I would suggest for down the line as our goal is if we have a free agent option that specifically takes into account social equity program participants that are not in the entrepreneur track, but are in the job related tracks, that they wouldn't be taking advantage of the licensing fee waivers or the application fee waivers. Instead, they should have an agent registration fee waiver, and we should guide them through the background check process, and then we should connect them with those that are looking to hire as someone who is an agent that is ready to go and make up for some of those other disadvantages. So I agree with the group's recommendation, and I would like to consider what I just described for next time.
Great, thank you.
Can I just make a quick point of clarification, Chairman?
Go ahead.
So just to address Commissioner McBride's comment and follow up on Commissioner Flanagan's comment. So the legal is working with the group in looking at whether the renewal would occur every 3 years or some other amount of time in sort of taking into account what industry standards might be for background checks. So that number may shift in what our findings are, but I just wanted to clarify that we are considering that in the drafting of this proposed regulations.
Thank you, Pauline. I'm looking. Are Commissioners McBride and Flanagan? Is your connection okay?
Yeah.
Commissioner McBride, you're on mute.
It's fine now, but it's been glitchy a lot.
Okay.
So.
Yeah. Let me know if we need to make some adjustments. I'll weigh in as well. Commissioner Flanagan, I agree with the direction that the group is heading. I support Commissioner Title's comments in terms of future direction, but in terms of this round of regulations, I absolutely support where your group is heading on this. So thank you.
Thank you.
Any other comments before we move on to the next topic?
Mr. Chairman, may I?
Mr. Executive Director.
Thank you. I want to just touch on the technology piece of this too.
Sure.
It's happening simultaneously, and this is honestly one of the biggest concerns I think we hear from industry, from just a pure burden standpoint of all of the different agent registrations that are required, which this proposal and future proposals won't get rid of, but it's the physical card printing aspect is we just don't have a better solution yet. We're working on it now, which is we have all the data we need. Using, for instance, a vertically integrated business, both in the medical as well as adult use side, could result in having six registrations for one individual or more, depending on the volume of businesses and licenses. That would require us to print each of those cards separately.
Right.
We're exploring now is one card or ideally one card for all of those registrations with a link to a data feed, which we maintain.
Right.
We have that information. We're exploring it now. But I've talked to many folks in the industry about this. We understand it. We're working, I think, aggressively toward a solution. It just doesn't sync perfectly with this round of regulations, but I don't want that to suggest in any way that we've abandoned that approach or that
Right.
goal or objective. And I think it's really important, even from our own standpoint, printing one card is obviously cheaper than printing 6 or 8 or 10. So I just want to make it clear that this is not something we're going to prolong or delay on. It's really just trying to get it right.
I appreciate that, Mr. Executive Director, and I'm sure that my appreciation is dwarfed by the appreciation of the industry and its employees. So, thank you. If there are no other comments on this, let's move on then to the next topic. We are turning it over to Commissioner McBride for the next 1, 2, 3, 4, 5 topics. I'm going to ask Commissioner McBride to let me know when she would like to take a break. We've been, meeting for an hour and 10 minutes. I wouldn't mind taking a break, over the next half hour, 45 minutes or so. But Commissioner McBride, will you kind of let me know when you think it's a good break time, given that you're on for the next 5 topics? Have we lost you?
The commissioner just let me know, this is Erica, just let me know that her feed is out.
Okay. Well, why don't we since I wanted to take a break sometime, why don't we take a break right now, Erica, and hopefully we can get Commissioner McBride back online while we take a break.
Sure thing.
Okay, so it's 11:12. I would propose we take a break till 11:25. And if we can reconvene then and hopefully have Commissioner McBride back, because we need her for the next part of the procedure. So we are on break till 11:25. Thank you. Erica, we're back live.
Not just yet, Mr. Chairman.
Okay, let me know when we're ready, okay?
Okay.
Okay. Commissioner McBride, are you back? Oh, she's calling in. Great.
Hello.
Hi, how are you? So you have no internet at
Thought
all?
I paid my bill this month. But...
Are you okay leading the next part of the conversation over the phone, Commissioner McBride?
I can try.
Okay, I will do my best to make sure that I give you opportunity to respond. So I won't see you raise your hand, but I'll make sure that there's no issues. And again, what I was saying before you lost your connection, the next 5 topics are yours, and you've indicated that you think some of them might take a while. So I'm going to ask you to let me know when you feel like a break is both, it's a good time for a break and when you feel like you need one, if that's okay.
Mm-hmm.
So go ahead. Can you see the screen or not?
No, I can't see anything.
Okay.
I have nothing right now.
Okay. So the topic that is up right now is research licenses. Would you like me to read the slide, or how would you like to proceed?
No, I'm ready to go.
Okay. Well, then go ahead if you wouldn't mind, and the conversation on research licenses.
Okay. So in my opinion, enabling a structure for research on cannabis to move ahead is probably the most important topic that we're going to be discussing during this round of regulations. And I say that because the data that I hope would be provided by a robust, accessible, and logical research structure has the potential to touch on pretty much every aspect of our regulations. And it goes to the core of our mission to implement and now sustain a safe, responsible, and equitable industry. And in developing these recommendations, I want to give thanks to Andrew Carter, who's our Associate Enforcement Counsel, and to Dr. Julie Johnson, our Research Director, who contributed significantly to this. So I think it's important that we acknowledge at the outset, and in making these recommendations, we are acknowledging the limitations imposed by external factors, and by that, namely federal scheduling of marijuana, while keeping in mind what we'd like to see and balancing creative thinking with pragmatic planning to get there. So included in the materials is a crosswalk that attempted to break into manageable pieces the major considerations and provide a basis for comparison by looking at the research structures that exist in 2 other jurisdictions, and that's Colorado and Connecticut, Connecticut being medical only. Ultimately, these recommendations borrow from both of those jurisdictions, and in some cases, they're a mashup of what our reg writing group viewed as the best fit for Massachusetts. So the highlights of the recommendations are as follows. First, we would establish a research facility licensing process. Right now we have the license in place, but we don't have a process around that to license a physical location, as well as a research permit, which would be required to conduct individual research projects. A facility could potentially have multiple permitted research projects ongoing. All marijuana or marijuana products used in research would be sourced from or grown by a commission licensed establishment or an MTC, and existing licensees could join together to pursue a research permit. A facility could be located at an existing research institution such as a university or hospital, or at a marijuana establishment or MTC, provided that the existing marijuana establishment or MTC and the research facility are commonly owned and clearly physically separated. The regulations would set forth what types of research could be conducted. It does anticipate human and animal-based research, but these recommendations would presume that the commission as an agency may choose to phase in particular types of research. So animal and human-based research very well may be further down the line. It may be that the commission would choose to start with a plant-based research process. The regulations set forth what an applicant for a research permit would need to provide, and a central component of any human or animal-based research would be approval of the project by an institutional review board or IRB. Additional requirements would include, but not be limited to, identification of the lead investigators, including the name of a medical doctor in good standing who would monitor participants for any human-based project, or the name of a veterinary doctor for any animal-based project. It would require a detailed research protocol, detailed safety protocols, articulated goals of the project, information about the composition pool of the subjects, a copy of the informed consent form or a waiver of consent, the quantity of marijuana anticipated and disposal processes, and disclosures or conflicts of interest among there are other things that would be included in that list as well. And the regulations would set forth what would be evaluated to receive a research permit, and provide audit authority to the commission for delineated reasons. So that's sort of the summary of, I think, the high points of the recommendations, but in that crosswalk that is provided, there are there's more detail and more context for the questions that we were trying to answer in making some of the recommendations. So that's sort of where the group is right now. So I'm happy to take questions.
Thank you, Commissioner McBride. Commissioners Title or Flanagan, or comments or questions for Commissioner McBride?
I want to thank Commissioner McBride for this work and her writing team, because I think this commission has relied on data. It since the inception, a lot of our research agenda requires a lot of data that doesn't come necessarily from the commission, but from a variety of places. And I think that this is an important piece to the regulations. At the same time, we're mandated to do a potency study with DPH that I think really has had some problems, given the fact that we need plant-based research. So relying on the IRBs gives it a huge level of credibility, and working with licensed academic institutions really is going to help us proceed in our data and our research collection.
Thank you, Commissioner Flanagan. Commissioner Title, any comments or questions?
I agree with Commissioner Flanagan.
Okay, Commissioner McBride, I support this as well. Do you need anything else from the full commission for your team to proceed on this? Again,
I don't think so.
This will turn into draft regulations that will be discussed and voted on in public, but to get to that point, you're set, Commissioner McBride?
Yes, thank you.
Great, thank you very much. So should we move on to topic 8, which is delivery?
Sure.
Eric, there we go. Again, I can read the slide for you if you'd like, or if you just want to go ahead and present, Commissioner McBride.
Hold on 1 second. Actually, I have a copy of it. I just need to get to it. Okay, so I need to thank Matt Giancola, who's our Director of Constituent Services, who drove a lot of the conversation around the considerations reflected in these recommendations that I'm going to make, and also give a shout out to Commissioner Doyle, who worked on components.
I'm sorry, I don't recognize that name. I'm sorry.
Yeah, I said her name. And so she worked on this, started getting some of these recommendations. My writing group was working on this, and her writing group was kind of working on it also, and we sort of put them together upon her departure. So the first recommendation is to change the name of the license from delivery only to just delivery to more accurately reflect the nature of the license. And I think the recommendations that we're going to follow will illuminate why that's one of the recommendations. The second recommendation is to clarify in our regulations that a marijuana retailer may hold a delivery license as a separate type of retail license. The reason for this recommendation is that under Chapter 94G, marijuana retailer is defined as, and I'm going to quote, an entity licensed to purchase and deliver marijuana and marijuana products from marijuana establishments and to deliver, sell, or otherwise transfer marijuana and marijuana products to marijuana establishments and to consumers. As such, the retail license cap requirements would apply because it would be considered a type of retailer license, with retailers being able to hold up to 3 retail establishment licenses, delivery licenses, or a combination thereof. The third recommendation. Yep.
I'm sorry, no, go ahead. I apologize.
Okay. The third recommendation is to clarify that delivery licensees may hold interest in other license types and vice versa. It does not change the requirement that marijuana and marijuana products shall be delivered from a retailer, or in the case of a delivery endorsement, held by a micro business, that it would be delivered from the micro business, but that the delivery licensee can have an interest in other types of marijuana establishments. And then the fourth recommendation is to allow delivery licensees to sell directly marijuana accessories, except for electronic vaporizer hardware, and that will become clear as we talk about the vape regulations, and allow the sale of marijuana establishment branded goods, provided that that makes sense with any potential changes to our advertising regulations. So we make these recommendations with the rationale for them being that last year during our discussion around delivery only licenses, the Commission voted during those policy discussions that licenses should not be foreclosed from having an interest in a retailer, but that's not necessarily clear in our regulations, and this change clarifies that intent. And these steps also expand the options available to delivery licensees and make the economic model more attractive and viable.
Can I just ask a question of clarification, Commissioner McBride?
Yep.
For number 4, would the accessories and the branded goods have to be sourced from the retailer, or could they be sourced from another party?
They wouldn't have to be sourced from the retailer.
They would not.
They could be, but they could be, right? But they would not have to be.
Okay, thank you. Thank you for the clarification. Commissioners Flanagan or Title, questions or comments for Commissioner McBride on this topic? Commissioner Title, I'll get you next, Commissioner Flanagan. That's okay, Commissioner Title.
A clarifying question first. So for number 3, a micro business could have both a delivery endorsement and a delivery license. Is that right?
No, I'm sorry. I apologize if that wasn't clear. It would, the micro business still is the entity that would have a delivery endorsement. They're not. It isn't expanding what a micro business can have.
Okay. I would propose considering that if they still have the ability to. I mean, if they're still required to comply with the requirements of both the delivery license and the delivery endorsement.
Okay, we certainly can consider that. I think it would require a change in the definition of micro business.
Right.
So, that's something that we can certainly, I think, as a we can, as a commission, kind of talk about what the implications of that would be.
Great. Okay. I'll leave that to you and your group. In general, I think these are all really great changes. I think they're great steps in the direction of making sure that these businesses are viable, as was the delivery endorsement idea in general. I still want to say for the record that I am very concerned about the financial viability and feasibility of these businesses, even with these steps. And I think we've tried really hard so far to come to a compromise with a model that we're all okay with, and trying to make sure that it's viable. So I just hope that as we go through the public comment process, that we look at the various models that people have, look at these changes, and consider the other changes that people might be asking for to make these delivery businesses more viable. I think the last thing that we want to do is lull people into an idea that a business is profitable when it may not be. And I certainly don't know one way or the other because this is new. None of us can know. And I have confidence that all of us will look at that data and make a decision based on it.
Thank you, Commissioner Child. Commissioner Flanagan? You're on mute. You're on mute. Okay.
Thanks, Mr. Chairman. I still have hesitations about delivery, and I understand that we're moving forward. But having said that, I was approached by a entity that is looking to do a subscription box, and a big part of that would be ancillary items. So as number 4, under the recommendations of number 4, my one question is, when we talk about branded goods, is it strictly clothing and the like, or is there going to be a definition? They're looking to expand to items, not necessarily clothes, but just different items. And I didn't know if that fit that narrative.
Commissioner McBride?
So the way that we approached that was in the draft that we have right now, we did explicitly say non-edible items. And the reason for that is because when we start talking about food items, we're potentially bringing in, I think, other regulatory bodies that, I'm not sure. I don't feel like I'm in a place right now where I would necessarily be comfortable expanding it to something like food items. I also think that it poses potentially an issue for, our investigators and our inspectors who are going out and sort of, what their responsibilities are, where they end and where another entity's responsibilities might take over. So in the current draft of the regulations, it is limited to non-edible, but that's understanding that there could be other items that are non-edible items.
Right.
The branded part, we were really kind of thinking about, the concept was really thinking about T-shirts, things like that. And not kind of other tangible goods that could be delivered.
Okay, thank you.
Thank you. So Commissioner Flanagan, can you help me understand the concept of subscription boxes, and specifically, are you thinking there's some regulatory language required if we want to allow that?
No, so this company would do sort of a themed box of goods and include with it a marijuana component. For instance, if there was a camping theme to it, you might have a s'mores where they would add non-infused chocolates, graham crackers, marshmallows, the tea light, the burner, things that you could cook the s'mores with, but then also have a marijuana product included. Under our current regulations, they wouldn't be able to ship that box as one box. It would have to be 2 components of it. And so they were trying to navigate their way through the regulations. And I believe they offered language to all 4 of us, or they should have at least, with regards to what they're trying to do. I personally don't think that it fits in what we're trying to do. And that's why I was asking Commissioner McBride what their team had meant by branded goods and accessory and ancillary items.
Okay. Commissioner McBride, any comment on that? Did you see the proposed regulation, proposed language from this group?
I am familiar with the concept that Commissioner Flanagan is speaking about. I actually I can rejoin the meeting. It looks like my internet's back up. Can I do that?
I certainly see no reason that we should prevent you from doing that if your technology allows. So go ahead.
All right.
I'm back.
I don't see you yet. Oh, there you go.
Yay. So I am familiar with the concept of what Commissioner Flanagan is speaking about. And I think that we're really talking about one particular business model. Mm-hmm. How do we build regulations that are going to be addressing not just that one particular business model, but allow for some expansion if we are going to allow for delivery of things that go beyond just marijuana and marijuana products and accessories. And so, I understand that by thinking about things like branded marijuana goods, we're sort of pushing the limit on that. That to me speaks to maybe alignment on, with our advertising regs. And so I kind of put it in a different category than expanding it to, other things like edible goods. Right. But, if we can think about a way that it allows for our inspectors, our investigators to be able to do their job, right, while acknowledging that there, may be other government entities, whether it's like, health commissions or something like that, that have a role to play. I would be open to giving that some thought. I just am not quite sure about the contours of that.
Comments?
I agree with her. I mean, I think that we have to be aware of the fact that this is one entity, and we have to look at the broader picture.
Okay. Commissioner McBride, do you feel like you got the input you need? I by the way, I'm totally supportive of all four of these. Given the clarification you gave me about number 4, do you need other input from the commission for your group to proceed on this?
Nope, I think we're good. Thank you. Okay,
very good. So let's move on to topic 9, which is also yours, Commissioner McBride, which is contactless retail.
Yeah. So this is.
I'm sorry, Commissioner Title. Did I not give you a chance to comment? I apologize.
Sorry, Commissioner McBride and Mr. Chairman, I was just wondering, just going back to the question of micro businesses holding delivery licenses, if this is a temperature check on that, I was just wondering if you could ask if other commissioners had thoughts on it.
Sure. Commissioner Flanagan?
I don't, as of right now.
Commissioner McBride, has your group did consider this, or?
We didn't consider it, and largely we didn't consider, I think, because my thinking about micro businesses has been that the establishment of that license really was intended to, it was intended to sort of speak to the, individuals who wanted to maintain sort of a smaller, focused presence. So, I think that comment on, what it would do to the micro business model. I mean, I would be open to hearing, during public comment, what people's thoughts are on that. My understanding and belief with the micro business model has always been that it was intentionally local. It was intentionally small, and it was with kind of that purpose that we move forward with it. And I think that's actually always been one of the more exciting parts about the micro business and the benefits of it, is that it is a intentionally smaller license. But if there's a if there's an evolving thought about that license type, then, you know, we should consider that.
Commissioner Tuttle?
That's just the process. Looking for. Appreciate it. Thanks.
Okay. Then can we go on to contactless retail?
Yeah.
Thank you.
So the suggestion here would be to allow retailers to opt into using contactless means of providing marijuana and marijuana products to consumers in the retail premises. It's envisioned that this would be used in a pre-order context and would still require fulfillment of the order by a registered agent at the MTC or at the marijuana retailer. And the rationale for it is, I mean, I think it's timely given the retail environment currently, but even after, you know, this particular public health crisis is over, which hopefully will be, you know, short order, it provides retailers with an option that increases efficiency without forsaking employment of individuals. And so there have been a lot of different types of, I think, you know, kind of non-human contact options that I've heard about over the course of the past several months. And so there are a lot of, you know, I think, possibilities out there. One thing that I'd be concerned about as we think about contactless provision of marijuana products is taking out the human element of it. And that's primarily because you know, so much of what we are doing, right, is trying to increase opportunities for employment and participation. And so I would just want to be careful in doing this, that we are thoughtful about that. But I do think that there is a potential benefit here, and that, you know, the timing on this is potentially right now.
Okay. Comments or questions, Commissioners Tuttle or Flanagan? Commissioner Flanagan?
Mr. Chairman, I think that, you know, we're moving in an age of contactless delivery for many different things. I think this is, like Commissioner McBride said, this is the perfect opportunity to talk about this and also allow the provisions for this. My one concern is that with certain types of contactless delivery, that we would be taking jobs away. And so I, you know, would like the establishments to understand that while this may be an option for their business model, at the same time, it's imperative that we have jobs for people that we've been, you know, looking to provide jobs for since our inception, and not to use this as a way to lessen our efforts to create those jobs.
So I completely agree with that concern, Commissioner Flanagan. Commissioner McBride, has your group thought about kind of how you do ensure that this doesn't lead to job loss?
Well, I think that's why, you know, I sort of point out here that it could be the requirement would still be that fulfillment of the order be done by a registered agent. So, you know, you're talking about potentially an efficiency where you have you know, a set of, like, I guess for lack of a better way to describe it, like a locker system, right? Where you have pre-orders that are put in there. Right. It's in a retail environment. Consumer comes in, they, you know, would be able to pay at that point potentially and get the pre-order while, you know, also having still the separate, you know, retail environment where it would operate as a traditional store, you know, once those are allowed to operate again, with consumers going in and being able to transact a purchase there as well. So it still requires the human fulfillment of the order, even though it's contactless on the, you know, the consumer to agent side of it, it would still require the agent to be fulfilling the order.
Right. Okay. Other questions, Commissioner Tuttle? Any questions or comments on this? Okay. Well, I think the sense of the commission is that this is, you know, timely and important. I think you've heard the considerations or concerns about this, but I think the sense of commission is this is something absolutely worth pursuing and putting in the draft regulations for discussion and review. Okay. Let's move on. How you doing, Commissioner McBride? Do you want a break? You want to keep going?
We can keep going.
Okay. So next topic, topic 10 is vaping. Commissioner McBride?
And this is moving into policy, right? We're in policy discussion.
Yeah, thank you for pointing that out. So we are now done with temperature checks. And the remaining issues are policy issues, which I suspect are going to be lengthier and probably more in-depth conversations than we've had to date. But let's start and see how it goes, starting with vaping regulations.
Okay. So the first thing that I want to do here is to say thank you to Genevieve Hall-Frisson, and who's our laboratory and testing analyst, and to Armand Enos, who is one of our investigators, who both did really truly outstanding work in providing both the context and in illustrating practical considerations as these recommendations were developed. So we began with what we adopted during our last round of regulations in the fall, when we were thinking about how to move forward with recommendations around vaping. And so we'll all recollect that last fall, as news broke about deaths and about illnesses connected to the use of vape products, that the Commission adopted language in our labeling regulations at 500-105 that required labels on concentrates to include the amount of specific additives infused or incorporated during the manufacturing process, whether active or inactive, including but not limited to thickening agents, thinning agents, and specific terpenes. So then, following the adoption of our regulations, approximately 1 week after that went into effect, the Federal Centers for Disease Control published findings providing direct evidence of vitamin E acetate, or VEA, at the primary site of E-Valley patient injury. And so accordingly, the CCC, through our executive director, issued the first amended quarantine order on December 12th. And pursuant to that order, the Commission tested quarantined vape products for VEA. While VEA was not detected in these regulated products, in some instances, heightened and concerning levels of heavy metals were. And so the question that we ask is why, and the reality is that we're not sure. The appearance of heavy metals in vape products may be due to a number of factors that could include time, device composition, temperature, usage, manufacturing processes, or extraction of the product for testing. And in the absence of sufficient information developed over the course of long-term studies regarding vape devices, we need to identify and monitor all the potential contributing factors that could impact the leaching of metals into vape products. We also thought about, as we were considering regulations, that we need to be aware of what is going into vape products, because there's agreement that while VEA rose to the top of the list of agents causing the most recent health concerns, it's not the only additive that could be used with potentially negative health consequences. And so research around issues like the degradation of terpenes and toxicity limits is lacking, and it's needed. And that's a shameless plug for the recommendation research licenses that I made earlier, and why that really is needed. So, in fact, the CDC in its final release on the E-Valley deaths and illnesses stated that vitamin E acetate should not be added to any e-cigarette or vaping products. And additionally, people should not add any other substances not intended by the manufacturer to products, including products purchased through retail establishments. And it's with this in mind that my group puts forward the following recommendations relative to vaporizer devices. So the first is that we amend the regulations to require that product manufacturers know, retain, and make available to the Commission information on what makes up their vape devices. And this means records of ingredients, additives such as terpene blends, component parts, or other materials obtained by the product manufacturer in relation to the manufacturing of marijuana vaporizer devices, and also that they use objectively reasonable efforts to identify and maintain records of the name and business address of the manufacturer of any cartridge, battery, atomizer coil, hardware, or other component of marijuana vaporizer products manufactured by the licensee. Second, we should require that certificates of analysis and safety data sheets for additives such as terpene blends need to be retained by the product manufacturer and provided to any licensee to which the manufacturer wholesales its products. And so to kind of define those, certificates of analysis summarize the results or findings from a product that has been analyzed, and it usually includes the test and the screening method, and it might even include information about the instrumentation used to screen the product. Safety data sheets contain information like toxicity or the risk if consumed or inhaled, and the chemical components of the product. Third, labels for vaporizer products should specifically include any inactive ingredients listed on the FDA's inactive ingredient database for inhalation or oral routes of administration. And I think that this is already implied by the amendment that we made last fall, but making it explicit reasserts the importance of thoughtfulness and thoroughness in the manufacturing process. Fourth, that we require labels to affirmatively state when terpenes are completely cannabis derived, or conversely, when terpenes include non-cannabis derived components. Fifth, that retailers provide safety data sheets for review upon request of a consumer. And sixth, that notice be posted at the point of sale and included in an insert placed in a consumer's bag stating that the vaping product has been tested for VEA, but that the vape may nevertheless be harmful to a consumer's health. I make these recommendations with the full acknowledgement that there's a lot that we do not know about the interactions of various factors and the potential for harm as it pertains to vapes. This approach was taken because it gathers data that we wish we had last year when we were in the throes of the eVALI crisis, and it's intended to enable us to continue to evolve as research evolves and the industry evolves. And if we see another challenge to the health and safety of regulated products here in Massachusetts, it gives us data from which to work with to address those issues. So I know that that's a lot to take in, and obviously the regulations or the draft of the regulations would include a lot more detail there, but this is the direction that our group, after a lot of really intense and detailed conversation, decided to head in.
Yeah, I just want to acknowledge this is an incredibly important topic, and I know your group spent an extraordinary amount of time on it and gave it a lot of careful consideration. So I just wanted to thank you for that. Ask for comments from Commissioner Title or Commissioner Flanagan, or questions for Commissioner McBride. Commissioner Title.
This is very good. I support it, and thank you and your group for your leadership.
Commissioner Flanagan.
I agree with Commissioner Title. I think that this is going to be one of the bigger issues that we have to contend with, especially because there's just a lot of unknowns. And I think that this is a really rational way to go about it. And I appreciate the work of Commissioner McBride and her team.
Thank you. I just want to second those comments. I'm actually really happy about the process that we're going to go through, which is, we'll put these into draft regulations, debate and discuss them, vote on them, and then allow for public comment and public hearings. I do suspect we're going to hear a lot from public health experts, from industry, and from other relevant constituencies, and I think that's going to be a great process. So I think this is great to put out there and encourage and engage in that dialogue. So I completely support the direction that your team is recommending.
Thank you.
Okay, I'm going to suggest that we go through your last topic, Commissioner McBride, which is testing, and then take a lunch break. Are you okay with that?
Yep, it's fine.
Okay, so then let's go to testing, please.
Okay.
Erica, next slide, please. Thank you.
Okay. So taking off from the vaping overview, we all know that testing is highly technical, and since the inception of the Commission's regulations, and actually dating back to the time before, when the medical program was still housed at DPH, the regulations have spelled out the framework for testing, but the specifications have been included in a testing and sampling protocol, which is then embedded in the regulations. So the approach that we took to this was, in reviewing testing requirements and needed updates, our group looked at both our regulations included at 500.160 and 501.160, as well as the more substantial and detailed protocol for sampling and analysis of finished marijuana and marijuana products, which is included in your handout. And recommendations on the regulations, if adopted, would be mirrored in greater technical detail in that protocol, an updated version of which is included, as I said before. And there are 3 major recommendations on testing. The first recommendation is to explicitly require that finished, ready-to-sell marijuana vape products be tested for heavy metals and vitamin E acetate, and give the Commission the authority to require additional testing for additional substances where necessitated to safeguard the public health or public safety and so identified by the Commission. And the rationale for that is the previous conversation, the outline of recommendations on vapes that I just talked about. The second recommendation is to add an explicit process for reanalysis or remediation of failed product at the option of the licensee, but to limit remediation to 2 failed tests. If the licensee were to choose reanalysis, it would mean resubmitting a sample from the failed batch to the same independent testing lab from which the product failed the first test. If the sample passes the second test at the original ITL, it would need to pass a confirmatory test at another ITL before being allowed on the market. And then if the licensee were to choose remediation, the remediated sample may be sent to any ITL, but the licensee may attempt to remediate contamination a maximum of 2 times, and 2 failed tests after remediation attempts would result in an order of destruction. So it's putting a cap on the number of times that product can be attempted to be remediated. The rationale here is that most ISO certified processes in other industries, whether for food safety or for other product manufacturing, have a cap on the number of times that remediation is allowed. And like other industries, it's important that we are upholding the standards that we set for contaminants. The process considers that 1 failure may be attributable to factors other than the product, like the lab equipment or to human error. And finally, establishing a process with a cap limits lab shopping. Our third recommendation, and in this one I need to say that in addition to Genevieve and Armand, Colin Soper and Nick Millen from our investigations team were really instrumental. This recommendation is to add 14 additional pesticides to the list of 9 pesticides currently tested for, as included in the protocol. The rationale here is that, as we're all aware, the EPA does not allow the use of registered pesticides on marijuana. MDAR states that it's unaware of any registered pesticide that would allow for use on marijuana under either federal law or under Chapter 132B of our general laws. And because of this, the use of pesticides on marijuana is prohibited in Massachusetts. Currently, MDAR identifies 90 or so pesticides that have the potential for use during cultivation. The source for these pesticides is MDAR and the Massachusetts Pesticides Analysis Lab, or MPAL. Of the 90 or so pesticides, currently we test for 9. And the cultivators, our licensees, are all aware of what those 9 are. The 9 are listed in Exhibit 5A of the protocol. So while ultimately all 90 or so pesticides should be tested for because they are all prohibited, there's no ITL that has the methodologies or the equipment right now to do so. The 14 pesticides that are proposed for an addition at this point in time as part of Exhibit 5A represent a collection of pesticides that have either been recently detected in some form or fashion or are suspected of being used during inspections either by MDAR or the CCC. And this means that they're currently a risk despite there being a ban on pesticides. Now, because the ITLs need to come up to speed and be able to test for these additional pesticides, we're proposing a phased-in approach, adding these 14 to our testing protocols and providing the ITLs with adequate time to purchase equipment and develop methodologies to do the testing, which is likely to be a 2 or 3 month lead time. The suggestion is that the list of pesticides here should continue to be added to periodically, but starting with these 14 seems to make sense at this point in time, and then developing how things should be phased in, over ensuing years. We can think about as we have kind of growing knowledge of what else might be potentially being used.
Thank you, Commissioner McBride. Questions or comments, Commissioner Title, Commissioner Flanagan?
I just want to say thank you. This is a tremendous amount of work that is going to have monumental effects, not only with the process, but also with consumer health. And I really think that it's important that you took the time to do this, and I really appreciate all your work on it.
Thank you. Commissioner Title?
Question on number 1, would the consumer be able to see that the product was remediated and retested?
So it's actually interesting because we had discussion about that, and I asked that question. So right now in the draft of the regulations, there is a requirement that the dates of testing would be included on the label, or would be included, so that you could probably draw that you draw the inference of how many times something has been tested. Think that ultimately, because the contaminants and because a failed test could be initially at the outset, like the first go around, it could be because of something that isn't necessarily related to the product. So it could be the way that something was extracted. It could be the equipment and calibration. So it sort of thinking about, well, what does it mean to say something has been remediated, or it's been reanalyzed? I think we need to give some thought to what we are, what we might kind of be saying if we put that out there. I mean, I'm certainly open to having that conversation, but I think we need to be a little bit thoughtful about, balancing that approach and making sure that because something has been remediated once doesn't necessarily mean, means that there are contaminants, but it's not clear how something got into the sample. So I think, I'm sort of open to thoughts on that. It's kind of, where we are right now is we had a conversation about it and decided that putting the dates of testing on there would maybe be sufficient for consumers to have knowledge of how many times something was tested.
That makes sense to me, and I'm going to be open to thoughts on that too. The vape changes, no concerns at all. On the pesticide changes, has there been any thought to, I mean, if we intend to keep adding pesticides anytime that there is a suspicion, at some point, if it gets excessive, if we want to consider random pesticide testing rather than, just making the list get longer and longer?
Yeah, so I think a lot of this is really about how we use that protocol and what ends up going into the protocol. The longer conversation that our group had was about establishing tables, right? And sort of, putting these 14 out there as kind of our table 1A. And then, in another period of time, if there are other pesticides that come to our attention as being issues, sort of developing, another table and embedding that in the protocol. I think that, ultimately, there shouldn't be any pesticides, right? So we can definitely think about doing random, random testing of things, but at the end of the day, there shouldn't be any pesticides on there. So it's kind of like, if we say we're going to kind of randomize something, I mean, I don't know, what the message is that, we're ultimately sending out there. You shouldn't have pesticides on there, like, period.
Okay. Commissioner, any other comments or questions, Commissioner Tuttle?
No, I think this is fine. I'm sure we're going to get a lot of feedback, but I appreciate the work on this, and I'm fine with it for now.
I have just one additional question, Commissioner McBride, which relates also to pesticides, which is your group suggests a phase-in period of 2 to 3 months to allow the labs to develop methodologies and purchase equipment. Did we get any input from the labs in terms of whether that timeline is going to be doable, or how great is the incremental expense? Does the technology exist? I'm just curious whether that was part of the dialogue that you guys had.
We haven't gotten input from the labs yet, but I'm sure that input will be coming. This is a lot of this is based on the experience and expertise of our investigators in the field have been conversations with the labs about how long it takes to develop methodologies and what is needed in order to do this particular kind of testing. And so I think that, in all likelihood, additional equipment is going to be needed by the labs in order to put this into place. And that in and of itself, never mind the methodologies piece of it, will have, there'll be a time lag there. So yeah, this is sort of the 2 to 3 months is the ballpark at this point in time.
No, that's great, and that's obviously the exact purpose of the process, is to develop draft regulations and allow for comment and public hearings and make adjustments as appropriate. So I completely support putting that out there, and I'm supportive of all the other recommendations as well that your group came up with on testing. Okay, so we're moving through this pretty well. We've got, let's see, 1, 2, 3, 4, 6 remaining topics. I will promise you the next topic will take longer than the ones that we've gone through thus far. But I think we're in good shape, and I appreciate both the facilitation of my fellow commissioners, as well as all the preparation that went into it from staff. So I think we're doing well. I'm optimistic we're going to get through this in its entirety today. So it's 12:15. Unless there's an objection from one of my fellow commissioners, I'd like to propose that we take a lunch break until 1 p.m. Is that okay with everybody?
Yep.
Okay, we are in recess until 1 p.m. Thank you very much, all. Welcome back, Commissioner Flanagan.
Mr. Chairman, how are you?
I'm doing okay. We're moving through this pretty well, I think. And you're okay?
Yeah, good.
Glad to hear it. Okay, it's 1 o'clock. Commissioner Tuttle, I can see Commissioners McBride and Flanagan. Commissioner Tuttle, you back? Commissioner Tuttle is back. Erica, are you ready to go?
Yep.
Fantastic. Okay, we're back in session at 1 o'clock. As I said, we have 6 remaining topics, and I've got 2 of them, and Commissioner Tuttle has the last 4. So let's get back into it. And this one might be the most challenging to get through, just because it's very complicated. Let me just give some context. I think everybody will recall that the licensing staff issued an opinion that to maintain economic empowerment status, the economic empowerment applicants needed to retain 10% equity ownership. We discussed that at a subsequent commission meeting and agreed to instruct for our executive director that guidance to change to 51%. I said at the time that I supported that. I voted for that change, or restoration, if you will, of our original intent. But I also said that I thought it was important for us to contemplate reducing that threshold, even though I think there are pros and cons around that. And I said at that time that I thought the right way to address it was in the regulatory process. So that's what I'm intending to do now. I will apologize. This got very complicated. I went down as, to use a phraseology that I promised Commissioner McBride I would never let her forget. I went down a rabbit hole on this, but I want to thank the team I worked with, particularly Christopher Smith, our Associate General Counsel, who really helped put some structure on this. The rest of my running team, Commissioner Tuttle, appreciated her help. And I also spoke to a number of economic empowerment applicants to just get their thought on this. Unsurprisingly, as I did so, I got very different opinions. So this is a complicated one. I have an opinion that I'll share, but I also understand the other sides to the argument. So I very much want to get the input of the entire commission to figure out how to proceed on this. Just to give some structure to the conversation and the rabbit hole that I went down, I think there's kind of 2 very high level issues that we need to talk about. And then there are some recommendations about reporting requirements to the commission that I'll go through, but I think those are more straightforward. They're important, but they're more straightforward. So let me just talk about the first 2 issues as I see them. First is when we did ask the executive director to update the guidance to say that economic empowerment applicants to maintain their status and the benefits of that status needed to have 51% or more ownership of the enterprise. I believe that's actually in conflict with our regulations. If you look at the regulations, which are right on the screen right now, that define economic empowerment prior applicant, they need to meet 3 of 6 criteria. 3 of those criteria talk specifically about ownership, 2, 3, and 4. And they all talk about majority or 51% requirement. The other 3, 1, 5, and 6, they don't have the same requirements. It is quite possible that you can meet economic empowerment requirements without having a 51% threshold. And I think we just need to be clear about that. The intent of the commission, it seems to me very clearly from our last conversation, was that you needed to retain majority control to retain your economic empowerment status and benefits. And I think that it's my opinion, at least, that we might need to change our regulations to reflect that, because I'm not sure that there's not a contradiction. But the second topic, so topic 1 is, do we want to modify our regulations to be consistent with that judgment that economic empowerment needs to maintain 51% ownership? The second, and I think maybe more complicated topic, is, do we want to relax that standard? And the recommendation from my group, but again, I recognize that this is a difficult topic and has differing opinions on it. My recommendation, our group's recommendation, is that we consider reducing the required equity ownership of to 51 or to 33%. Can you leave the last slide on, please, Erica? My recommendation is that we take it down to 33%, and my logic for doing that is that I believe that we should not dictate to applicants and to entrepreneurs how they run their business, as long as they adhere to our regulations, obviously, nor how they raise equity or how they structure the investments in their business. My proposal would not require people to give up any amount of equity. It would just allow them to go down to 33% if that was in their opinion, in their best interests. The logic behind that is it is quite possible that an entrepreneur would decide that a smaller piece of a bigger pie is in their best interest. And I don't think that we as a commission should tell them that they don't have the opportunity to do that. I think it would provide a great deal more flexibility to economic empowerment applicants raising money and structuring the finances, and I think that would reduce one of the barriers that I think people have run into in terms of starting businesses. So I think the flexibility is important. I think it's important to put in some safeguards. The safeguards that we proposed are twofold. One is that, as defined in our regulations, you could go down to 33%, but the economic empowerment applicant would have to retain management control. So they might, end up with lower than a majority of equity, but they would still have complete control of the business from a management standpoint, which I believe is really important. We also, on our team, proposed that if an applicant did go down below 51%, that however the profitability or cash flow of the business was distributed, it had to be at least proportional to the economic empowerment's ownership, so that we would avoid structures where people would have nominal equity, but not receive a proportionate amount of the financial benefits of the business. And so those were safeguards against abuse. But the basic point and my basic belief is that we should be both providing more flexibility to people in terms of how they structure their finances, and we should not be telling them how to do it. We should allow people to use their best judgment in terms of what's in their personal best interest in terms of building and benefiting from a successful business. So those are the kind of the first 2 questions, and again, I'll get into some of the reporting requirements that we think are appropriate. But I wanted to get the group's input on 2 things. First, do they feel, as I do, that there is a conflict between our regulations and the guidance that we gave out a month ago that said that to maintain economic empowerment status, the enterprise, the applicant that got economic empowerment status needed to retain 51% ownership. Does anybody see any conflict there, or am I just on an island by myself here? Commissioner Title.
On that question, while I don't see a conflict, I like the change. I would be okay with the change.
Okay.
We're only talking about that one to begin with, right?
Yes, that's, and then we'll come back to whether we should redo, so let me just clarify to make sure that I'm hearing you correctly. So you're in favor of making it clear that there needs to be an equity threshold for people to retain their economic empowerment status and benefits, correct?
Yes.
Okay. Commissioner Flanagan or McBride, do you care to weigh in on that?
I think Commissioner McBride's having a problem with her. It looks like she's gone.
I don't see her. Well, while Erica is trying to get her back into the meeting, let's pause, see if we can get her back in the meeting so she can hear your comments, Commissioner Flanagan, if that's okay.
I agree with Commissioner Title. I
okay.
am fine with that.
Okay. Do we want to start the conversation? Commissioner McBride will get back in quickly about given that, so there is, and we'll make it explicit, this minimum equity threshold to retain economic empowerment status. Do we want to begin the conversation of whether that's you back, Commissioner McBride?
Yeah, I don't know, my team's shut down again.
Really?
All right, okay, go ahead. Yeah, go ahead.
So I have gotten feedback from Commissioners Title and Flanagan that they think, making it explicit that there should be a minimum equity threshold requirement to retain economic empowerment status, that they support that. So I wanted to get your thoughts on that. And then the second question will be, if we do retain a minimum threshold, should that stay at 51% or perhaps go down to a lower number? So can you just respond to the first part of that, please, Commissioner McBride?
I agree that there should be a minimum threshold.
Okay.
I think that I think 51% is where it should be right now.
Okay.
So I guess in response to the second part of that, I'm in favor of keeping it at 51%.
Okay.
I think it's extraordinarily important that we are promoting minority ownership of businesses, and I think that that was the importance and the relevance of establishing the programs that we have established. And I think that our work is not done there. And at this point, we should keep it at that threshold.
Okay, well, thank you. So I guess we're into the second question, which is should the threshold stay at 51% or should we allow for flexibility to go below that? And we've heard from Commissioner McBride. Commissioners Title or Flanagan, do you have an opinion on this topic? Right. Commissioner Flanagan?
I think the 51%, as Commissioner McBride said, is important. I think we need to do everything we can to ensure that the integrity of what we're trying to do gets accomplished, and I think that does that.
Okay, thank you. Commissioner Title?
I would be okay with moving it down to 33% ownership as long as the economic empowerment applicants retained control of the company, and we defined control really clearly, and we had some safeguards in place to make sure that they maintained control. I think
right.
That would be in line with the goal of the program.
Okay. And that's obviously my perspective as well. I would be certainly open to, if we go down that path, I would certainly be open to feedback on whether the controls that we put in place are sufficient, in your opinion, Commissioner Title, or whether we need additional controls. But we're in a situation now because of having a four-person commission, where it seems like we have pretty clear two people saying we should retain 51% as the threshold, the minimum threshold, and then Commissioner Title and myself believing that maybe reducing it would be beneficial. Under the rules, as I understand them, if there is a tie, then the motion gets voted down. So I would be. I guess I don't hear a lot of flexibility here. I really do believe, as I said, it's important to give people flexibility. It's important to not dictate how they structure their business. I believe this, and I feel this strongly. I personally believe this would make it easier for economic empowerment applicants to raise the necessary capital to build a business. And I think this actually is an important part of helping us accomplish our objectives. I think we're all aligned. I don't think there's any question whatsoever. We're all aligned on what those objectives are. This is clearly a discussion and debate about the best means to that end. And I don't know that I have a great idea about how to resolve what seems to be a difference of opinion, which I knew was going to happen because this is a very complicated topic. I welcome any comments from my fellow commissioners that might attempt to sway the other side. Go ahead, Commissioner Title.
I think that if we are split here, then we should. Well, we have to go with what the present situation is, which is 51%. I'm pretty comfortable with that actually, because if we do have economic empowerment businesses that want to retain control, but have a situation where they feel they need to go below 50%, and maybe a third is too low, maybe it's something between a third and majority, they would certainly have the opportunity to make that case to us during public comment. And I'm sure we would all take it very seriously. In my heart, I guess, I'm like a purist, so part of me does want to stay with the 51%. It's just that in the current circumstances that we're in, I don't want to hold people back, from moving forward with their business if maintaining 51% is impossible for them. So maybe we just stay with the current status quo, but we want to specifically invite public comment from the people who would be impacted that would like to see this change.
Yeah, I think that's probably a great suggestion. Let me not cut off is Commissioner McBride or Flanagan any comment on that other than what you've made already?
Yeah, can I say something?
Yeah, please go ahead, Commissioner McBride.
I agree with Commissioner Title. I mean, I think that we will get comment back on this. My preference for not dropping it down to a third is really in line with the reason that we put these programs together and why the legislation makes them a cornerstone. But if we get feedback that people are hamstrung from being able to attract investors, and there's a rationale for doing that, then I think we should be open to that. But I guess I just want to make clear that my hesitancy with that is really just based on wanting to make sure that we are promoting as much as we can the majority minority ownership in businesses, as I think we've kind of tried to do since the outset.
Thank you. Commissioner Flanagan, I have a couple of closing comments on this topic, but before I do, any additional comments from you, Commissioner Flanagan?
Not really. I mean, I think I just go back to the rationale that I really want to ensure that the ownership levels are there, and that I understand that we could be going through some difficult times now, but that these regulations are going to have a lasting effect. And quite frankly, I don't see us coming back anytime soon to do these regulations again. So
that's correct.
I think to add some stability to this industry, and people are going to have the comfort level of knowing what that percentage number is, I would rather leave it at 51%. Having said that, I understand that we're in the process now where we're going to ask for input from the public. So my suggestion is for the public to participate in this process and actually verbalize their thought process on this and what they'd like to see.
Great. Thank you, Commissioner Flanagan. I go ahead, Commissioner Title.
Thank you. Just one more comment. I think the very most ideal situation is that we stick with majority ownership, and then we have opportunities that are actually financially feasible where the barriers are low enough that the people in these programs, will be able to start their own businesses and own them successfully. So as part of that, I'm actually pretty heartened to hear that we want to lean toward majority ownership and then focus on these other things, I think is the implication. Then I hope we'll do more, in terms of municipal outreach, in terms of considering the feasibility of these businesses and some of the requests that have come up before. And we're looking at, wholesaling products or, being able to potentially pick up your product from another facility. Some of these issues that have come up, I just hope we'll consider them in the light that we want these businesses to be feasible. And of course, we want them to be compliant too. We want them to be safe. But we want a situation where the majority owners are the people in our programs, and they're not going to end up in a situation where, they're heading towards bankruptcy or they're heading towards using their life savings on a business that doesn't end up being feasible.
Okay. Thank you. So look, I'm very comfortable with where we are in keeping it the same, but inviting public comment during our public comment and public hearings. I will tell you that based upon a very small sample size, my expectation is that we're going to hear very divergent opinions as we do get input during the public hearing and public comment period, but that's fine. It just reflects back. This is a difficult topic, but I'm perfectly happy, and I appreciate the input of all of my fellow commissioners, and I'm perfectly happy with the recommendation. We'll take it back into my writing group. I will point out, just to make sure that there's no confusion, you can, as an economic empowerment applicant, take your equity below 51%. Nothing stops you from doing that, other than you do lose the benefits of being an economic empowerment applicant going forward in terms of reduced or eliminated fees, but nothing stops somebody from doing that if they think that's the appropriate trade-off. So, but I'm very comfortable with where the group's consensus seems to be on this matter. So thank you very much for your input, and let's move on. There, as I said, were a couple of recording requirements. If you could flip slides for me, Erica, I'd appreciate it. Keep going. No, keep going. Okay. I'm sorry, if you wouldn't mind, keep going. I appreciate it. Now keep going. If you, I apologize. Okay, here we go. Now go back to issue 4. One slide back. I'm sorry. So a suggestion has been made that we introduce a requirement that commission staff produce a list updated for each public meeting that lists all applicants and licenses with EEA status. I think that's a pretty straightforward question. It obviously has staff implications, so I'd appreciate the perspective of our executive director on this. The recommendation that the group had was to do B, to request through the executive director that this list gets updated for each public meeting. But again, I'd welcome some guidance from my fellow commissioners on whether this requirement seems appropriate, and also, as I said, our executive director in terms of the feasibility of this. Any comments on this? Commissioner Title?
Thank you for this. I would defer to the executive director on whether B or C is appropriate, but I think it is really important to have this list, especially as time goes on. A lot of different parties are stepping up in terms of companies' positive impact plans, and municipalities and consumers, all of these stakeholders that want to support economic empowerment applicants. We want to make sure that there is a current list of who those businesses are.
Thank you. Before I ask the executive director for his perspective, Commissioners McBride or Flanagan, any comments on this or guidance? Commissioner McBride?
If we were going to do this, I would support B. I think that this is clearly important information for us to have. I do think that it doesn't quite fit with our regulations to be putting in a requirement on our own staff in those regulations, given what the scope of our regulations is. So I guess that if we were going to do this, I would take the route of B as opposed to C. Yeah,
okay. That was the recommendation of our group. Thank you for that. Commissioner Flanagan?
I understand why this information is important. I don't necessarily understand why we have to have it for every public meeting that we have. I think a lot of things go into the timing of licenses, whether it's RFIs or documentation that has to be required to come back or that hasn't been submitted. And I would hate for people to get a misrepresentation of why people aren't on the list and to start that dialogue and going back and forth. So my suggestion is not to change anything, but if the will of the commission is to do something, I would rather be.
Commissioner, or excuse me, Mr. Executive Director, do you have thoughts on this?
Sure. Thank you, Mr. Chairman. I'm happy to produce this information. I think it's something we maintain. I do understand the importance of it, especially to Commissioner Title's point. There are a number of applicants that have secured their certification as economic empowerment applicants, and then once submitted or once that business evolves, they may no longer maintain that status, and so it may lead to some confusion as well. So I think a list of this sort would be valuable for identifying which applicants or licensees have maintained that status, and to the information on B and C as far as what has lapsed as well. My takeaway from this primarily, though, is that information and data is really important, and we ought to be publishing as much information as possible to allow licensees and consumers and others to make decisions with that information. So I defer to the commission as far as what the objective is. The one concern I would add about adding it to regulation is that we also produce a number of other things that are not based on regulation. And I'd rather not have a, it'd be my preference at least to not have a two-tier system of information that is required by regulation and information that is published at a discretionary basis. So the commitment, of course, is that we'll do this.
My hearing of you, Mr. Executive Director, is that you're suggesting that B would be the approach you'd be more comfortable with?
I think I'm absolutely, yeah.
Okay. Unless there are any objections, as long as it's on the table, perhaps I could ask for a motion and a second, and we can just vote on this right now, unless there's further comment or debate. Then could I ask Commissioner Child, would you make a motion, please?
Sure, so moved.
Could I have a second, please?
Second.
Let's record show that Commissioner Title made the motion to approve, seconded by Commissioner Flanagan. Commissioner Flanagan, your vote?
Aye.
Commissioner McBride?
Aye.
Commissioner Title?
Aye.
Commissioner Hoffman, aye. Let the record show the Commission unanimously approved the motion, which is to adopt option B on this slide. Thank you very much. Erica, can we go to issue 5, please?
Mr. Chairman?
Yes?
Did we skip over issue 3?
We might have. Let me go back. Would you go back to issue 3, please, Erica? Sorry about that. If I did, I apologize. Okay, yeah, I guess, you know, I kind of made this point, but maybe we should discuss it before I made it, which is that, you know, we have decided that we're going to keep the 51% equity threshold. The question before us is, therefore, if somebody falls below that threshold through their own choice, do they lose all of the benefits or some of the benefits with respect to EEA status? And again, once someone has been licensed or once someone has been given priority, then the remaining benefits have to do with application fees and license fees. Separately, our regulations with respect to delivery and social consumption require that to participate during the period of the first 2 years or longer, they have to maintain 51% equity ownership. So that you know, that benefit disappears by definition. But the question is, do the other benefits that belong to EEA status disappear entirely, or do we keep some and remove some if an EEA applicant decides to, for whatever reason, go below 51%? I made a statement, which again, I apologize, it was premature, that my opinion is that all the benefits disappear if they choose to go below 51%, but let's have that conversation. Thank you very much, Commissioner Title, for noticing my omission. Do you have a comment on that, Commissioner Title?
And thank you for the staff for pointing it out, actually. If I agree with you, I agree with option A.
Commissioners McBride or Flanagan?
I agree.
I agree with option A.
Okay, thank you. I apologize. I thought that was the case, but I made an assumption, and I appreciate Commissioner Title again making sure that it was explicitly discussed rather than just assumed. We can go to issue 5, please. Again, this is another reporting issue, which is whether to require EEAs to report all changes in ownership to the Commission. Obviously, it doesn't change the threshold that the Commission has to approve. It's still any changes that are greater than 10% in terms of equity position, but this is requiring that all changes in ownership get reported to the Commission. And again, very much our writing team would very much like to get a sense of the Commission before we draft regulations here. So I'm very interested in thoughts and input from my fellow commissioners on this. And it's it's a kind of an on-off thing. Either we don't change it or we put in a requirement that all changes of ownership for EEA organizations are reported to the Commission. So I'm very interested in input from my fellow commissioners. Commissioner Title?
I would like to see all changes in ownership reported for similar reasons as for why we wanted to maintain that list. Just because.
Sorry, would you repeat yourself, please, Commissioner Title? I apologize.
Yeah, sorry if I broke up.
No, I just got distracted for a second. I apologize.
It happens to all of us. I think for similar reasons as why we need that public list of economic empowerment applicants, I would like to see all changes of ownership disclosed. Because this is a relatively small group, it will hopefully not be a large number of changes being reported. But just given that, just given the way that the benefits have evolved and are continuing to evolve, I would like to keep an eye on the way that the ownership is changing.
Okay, thank you. Commissioners McBride or Flanagan, thoughts on this?
I agree.
Commissioner Flanagan?
Yeah, I agree as well.
Okay, thank you. That's sufficient guidance. Our group will turn this into regulatory language that will be discussed and voted on when we get to that point. So thank you very much for your input. I'm trying to remember, this is such a complicated thing. Is there an issue 6, Erica? Yes. And again, this is another reporting requirement, which would require target community members to certify each year that they have exercised control and retain requisite ownership of the EA. So it's related to the previous 2 conversations. And again, my writing team is just looking for some guidance about how the Commission feels on requiring this reporting or this attestation, if you will.
Can I ask a question?
Yes, please.
What is this going to entail? Is it just a form they're going to fill out? Is it paperwork they have to submit? How much work is going to go into this for the entity?
Well, we haven't kind of fleshed out to that level yet, Commissioner Flanagan, because we wanted to get a sense of the direction of the Commission. But I would welcome your input and thoughts on that. If the decision of the Commission is that they think this would be a worthwhile change to our regulations, I would welcome your thoughts on kind of how best to accomplish it. But the first question is, do we think this is a reasonable request? And then if it is, as I said, we'll draft regulations with input. So.
My suggestion is that if this is going to create an undue burden on the applicant, then that we not do this. I think that, economic empowerment applicants have a lot to contend with as it is. I would hate to add more paperwork to them. And if we do add more paperwork, if it's something more than just a signature on a piece of paper certifying that it is what it is, I really don't think it should be more entailed than that.
Got it. Thank you. I appreciate that input. Commissioners Flanagan or McBride or Title? Commissioner Title?
I think this is documentation that they should be keeping anyways. I think if you're an economic empowerment applicant and you are representing that you're continuing to meet 3 of 6 criteria, you should be able to document that. I think once a year is reasonable, but if that seems like a lot, we could make it, 2 years. But I do think it's necessary.
Thank you. Commissioner McBride, your thoughts?
I share concerns about layering on more for for applicants to do. But that being said, if we think that this is something that's going to be useful, I would just ask that we do this with a minimum of burden on the applicants. So we think this is important. I'm supportive of having this attestation. I just think that it should be fairly minimal.
Okay. Thank you. So I'm going to take this as this is something that my writing team will take up. We will work in consultation with the executive director and any designees he suggests from staff to try to do it in a way that is minimally disruptive and minimally incremental in terms of the amount of additional work required on the part of the EAs and our staff. And try to accomplish that objective in that minimalized fashion. And I welcome input from executive director and other staff on that. And we'll come back when we discuss draft regulations with proposal about how we can accomplish this objective with minimal disruption. So thank you for that. I believe we're on my last topic, and then as I said, Commissioner Title has four that her group wanted to bring to the table today. So this is about social equity program, which right now says there's a 10% threshold for ownership in order for the organization to access the benefits that SEP programs get in terms of expedited review, fee waivers, and discounts. It's kind of a comparable question to the one we started our after lunch session on, which is 10% appropriate, or do we want to put a higher threshold that would both encourage majority ownership and also, I think, probably have an economic benefit on the commission in terms of a fewer number of organizations that would actually benefit from this. So simple yes or no, complicated question, but simple yes or no. Do we keep the 10% threshold, or do we raise it to 51% or some other number? And again, my team can write the regs pretty easily. We're just looking for guidance from the commission on this. Commissioner Title.
Unfortunately, I don't have an easy yes or no. I have a suggestion.
Please.
So I think the 10% is a concern because the numbers of social equity program participants are going to go up dramatically every year, as we have new cohorts. And you could potentially be a 10% owner, and then the 90% owner could be McDonald's or Starbucks or some company that I think by our definition doesn't need a fee waiver. And so considering that licensing fees are $1,000 a year for a business, we should be very deliberate about the group of companies. But the reason I don't have a yes or no is because I don't think it necessarily needs to be micro businesses and minority-owned, veteran-owned, and women-owned businesses. I got some very smart feedback from the staff that, or from different staff members, that if we do stay with minority-owned, veteran-owned, and women-owned businesses, it should be when they have the certification from the Supplier Diversity Office. And we may want to also consider keeping it small businesses. So we could do that by certain tiers, maybe just cultivation tiers 1, 2, and 3, and then retailers and product manufacturers. And we could also consider tying it to performance indicator, like their net profits, or some way to measure that they're a small business. So I don't have a complete recommendation for what the group should be, but I think maybe we should start out smaller and then we can always expand to more groups. So maybe small minority-owned, veteran-owned, and women-owned businesses and majority-owned social equity program participants.
Okay. Commissioner McBride, Commissioner Flanagan.
I like Commissioner Title's suggestion very much.
Thank you. Commissioner Flanagan?
I agree. I think we need to start off smaller and see what happens.
Okay. I think that gives my group enough guidance to work on. I think that there's some complexity in Commissioner Title's proposal. I like it, but I think there's some complexity. And so what I offer is my best good faith effort to try to get it done so that in the timeline we're working on, we can have draft regulation language for this group to discuss and vote on in the appropriate time frame. So I think we have the guidance we need, and we'll do our best to get it done in the time frame. So thank you. I think we're on to the 4 final topics, all of which came out of Commissioner Title's writing group. So I'm going to ask her, please, to facilitate the conversation on these topics. Commissioner Title.
Thank you, Mr. Chairman. Not all of these came from my group. This one, for example, was in group 2 originally, Commissioner Doyle's group. They decided not to take up the issue of buffer zones. And you might remember the previous suggestion was when we have a 500-foot buffer zone between marijuana establishments and schools, it's not defined how we measure that.
I do remember that. I do remember that conversation fondly. Yes,
I remember it fondly as well. So in the last round, I had suggested walking distance or odometric distance, but that was not considered doable by any expert that I talked to or that anyone in the group talked to. So abandoning that idea, I asked if we could consider a very narrow exception, which is when 2 cases. So one case is when there's an impassable barrier, such as a highway or a river between the 2 establishments. And in that case, it would be measured by the walking distance between the 2. And let me just pull this up, sorry. Okay, it would be measured from where it's currently property line to property line. The new measurement would be the property line of the marijuana establishment to the nearest entrance of the school. So that's the first change. The second change is if it's impassable, like a highway or river, it would be pedestrian travel instead of the route by which pedestrian travel is blocked. And then the third is what is called a flag lot. And that is when you have a lot which is shaped like a flag, where the marijuana establishment is in the flag portion, but then there is another part of the property that would not be able to sustain those operations. And so in those cases, that pole of the flag lot would not be counted. So it would be 500 feet from the property line, excluding that part of the lot. And I know these are somewhat specific situations, but the idea there is that we've narrowed it down to just a couple of exceptions that are pretty clear. And in those cases, the buffer zone would be measured in a different way than a straight line.
Okay, thanks. Comments from Commissioners McBride or Flanagan? Questions?
Mr. Chairman?
Yes, Commissioner Flanagan.
My one comment is, while I understand the need for buffer zones, and I'm supportive of buffer zones, my one question is the definition of a highway, because we have state roads that run through the middle of towns. That isn't necessarily like a 3-lane highway that we think of. So my concern would be if you're in a smaller town, you know, what's considered a highway, and how close is that to a K-12 building? And that's something that we can work off through staff as this process goes on. I'm not expecting an answer right now. It's just that when you initially think of a highway, you literally think of a regular highway, but I'm just concerned about the further west we go. You know, you've got Route 2 that goes straight to the Berkshires. You've got all these smaller roads that I want to ensure that we have that buffer zone from the schools.
Yeah, so that's a good concern, and I share it. I can answer that conceptually, but not technically. But conceptually, the idea is that if you could walk across it, as a pedestrian path, and that wouldn't be considered an impassable barrier. It would be just that if you couldn't walk across it.
Okay. I appreciate that. And then just for, you know, conversational purposes, not that this is included in this, but I've heard from people out in the Berkshires that they're concerned about bus stops. That's why I say that those little roads is because they're concerned about the location of bus stops, which we have nothing to do with. We don't set those, nor do we set the planning of these sightings of these facilities, but it's just been a concern that's been raised.
Okay, thanks. Commissioner McBride, any comments?
I don't have any comments at this time. I will be interested to see what the feedback is on this. I mean, I certainly have heard from many people who have struggled with exactly this, the measuring, and so I want to see what the feedback is during public comment on this.
Yeah, I completely agree. I think this is an area that we do need to provide some more specificity and clarity on. So I think it's appropriate to draft regulations. We'll discuss and vote on those, and then we'll see what kind of feedback we get. But I think the objective of providing more clarity here is absolutely appropriate and necessary. Commissioner Tyler, do you have guidance you feel like you need to take the next step here?
Yeah, thank you.
Good. Then could we go on, please, to the next topic, which is about expanding delivery endorsements? Commissioner Title?
Yes. And sorry, just to clarify, since that wasn't with a group, is it okay if I take that back to my writing group?
Yeah, no, I thought that what happened was when Commissioner Doyle left, that we took the topics that her group were focusing on and split them amongst the remaining 4 of us. So I thought this got assigned to your group. If I'm incorrect,
but in any case, it's with the group.
If I was incorrect about that assumption, I am now assigning that to your group.
Thank you.
Go ahead, please, on topic 15.
Okay, so topic 15 is something that I asked for the commission to have a discussion about. And this is another situation where I am not advocating that we expand delivery exclusivity at all. If it was on the table today, I would vote no. But the reason that I asked for this to be discussed is a couple of things. One, there's so much uncertainty around delivery licenses and what the demand will look like and how many businesses there will be and whether the businesses can meet the demand. And second, as the chairman mentioned earlier, it may be some time before we redo our regulations. And so I think we should think about what might happen in the time until we next change our regulations and making sure we have adequate flexibility if we do need to make any changes. And then third, that we do have a statutory mandate to encourage women, minority, and veteran-owned businesses. And those numbers have been going up, which is great to see, with the expedited review benefit that those businesses have. But at this point, that's basically the only benefit. So I think we should just keep in the back of our minds what are other benefits we can give that group. So with that in mind, the proposal here is that we add a provision to the regulations that the commission may choose to expand delivery-only licenses and delivery endorsements to cooperatives and women, minority, veteran-owned businesses. And the idea is there is that we've then included, along with micro businesses, economic empowerment, and social equity, we've now included all the different groups that we're trying to encourage under the statute. So that if there is a case where it seems like we need more applicants and we don't have enough for some reason, it would be up to the discretion of the commission at that time. I think the only potential drawback to consider is we are then giving a lot of trust, to a future commission. But I think I thought it was worth considering just given the uncertainty here.
Thank you. Commissioners Flanagan or McBride, any comments on this? Commissioner McBride?
So the delivery endorsement, when it was raised, when I raised it last fall, I raised it with the intent of it always being that it could be expanded, that we would start with micro businesses and that it could be expanded. And I think that leaving that discretion to a future commission, I am very comfortable with. I trust that we are setting a firm foundation and have set a firm foundation, and that in the future that we will give enough of an indicator of considerations. That being said, I would be interested if Commissioner Title had ideas about on what basis we would look to expand this, or what suggestions might be. I think it's always in my view the best practice to try to set forth as many criteria as you can that are in your head, like at the moment that you conceptualize something, but that also becomes, it's a double-edged sword, because then you put that down in writing, and then are people constrained by just that. So if Commissioner Title had some thoughts on that, I'd be interested in hearing them.
Thank you, Commissioner Title.
I had not thought of that. I think that's a really good suggestion. And I'm incredibly proud of the way that we did that with our exclusivity period in general, the way that we laid out the criteria. So I think that's a good idea, and I would like to do that. I don't know, because I haven't thought about it, what the relevant criteria would be here. It would be something along the lines of, if there is unmet demand that the existing businesses and applicants can't fill.
Okay, Commissioner Flanagan, any comments?
Not in addition to what's already been said.
Yeah, I have faith in whoever follows us, and I have faith in that, because I think we built a great foundation for that. I also I appreciate Commissioner McBride's comments, and I appreciate Commissioner Title, your willingness to try to bring some structure to that idea. I would really want to make sure that we preserve the flexibility, whether it's this commission or a future commission, that we're not locked into a specific decision, that there is room for discretion and flexibility based upon circumstances. And I'm sure you'll find the right balance there.
May I ask a temperature check question?
Yep, absolutely. Go ahead, please.
When I mentioned cooperatives here, I was actually thinking beyond craft cooperatives and including any business that meets the 7 principles that we laid out. So potentially a worker-owned co-op retail dispensary. And I was wondering how everyone feels about that.
I'll admit my own ignorance on that, and that I'd like to learn more about how that would sort of function. So I will tell me more. Tell me more, whether it's now or it's at the point of the public comment period. Yeah, I'd like to find out more about that.
Commissioner Flanagan, any comment?
No, I'd actually like to learn more about Commissioner Title's thought process.
So I would very much like to see that incorporated in the draft regulations, with the kind of explanation of kind of who qualifies and how and under what circumstances. But conceptually, I love the idea.
Okay, great, thank you. I kind of wanted to check that before I thought about it more, so I'll come back with details on that.
Thank you very much. Anything you have guidance you need on this topic, Commissioner Title?
Yes, thank you.
Great, then let's move on to the next topic, which is financial hardship documentation.
Yes. So this is the last topic. I will say that
there's one more topic after this. I'm sorry.
Oh, really?
Yeah.
It's fine?
I think you said you take the last 4, so
sorry.
We'll see. When we get there, we'll figure it out. Just let's work on this one.
Oh, okay. Yeah, no, that one's fine. Okay, sorry. So the issue here is actually quite straightforward, I believe, but I would like to just leave it at a temperature check, because we got a memo yesterday that I think is good, but I didn't get a lot of time to look at it yet, and I'd like to bring it back to my group where the institutional knowledge is. But the idea here is that we had received some complaints from patients that they have a financial hardship, but they were finding inconsistent requests for documentation when they went to different dispensaries. And so the suggestion was to make it clear that a valid Mass Health card would be an acceptable form of documentation, or a Social Security benefit verification letter. And let me read directly from the Social Security Administration website. What is a Social Security benefit verification letter? The benefit verification letter, sometimes called a benefits letter or a Social Security award letter, serves as proof of your retirement, disability, supplemental security income, or Medicare benefits. You may use your letter as proof for loans, housing assistance, mortgage, and for other income verification purposes. And then on a FAQ page, they actually refer to it as also being called a proof of income letter. So the idea here is that if for some reason you don't have a Mass Health card because you're not on Mass Health, you could use your Social Security benefit verification letter as proof of income. And I do have in my group the people with institutional knowledge from working with patients and from previously granting waivers based on documentation for fees. And this is what they supported as well. So I think it's straightforward. But the reason that I would like to actually not finalize it is because we got some comments yesterday suggesting that we add more ways to verify a financial hardship, including SNAP documentation and W-2s, I think. So I would like to just bring that back to my group and then come up with a final proposal.
I think that's fine. Any comments or any guidance for Commissioner Title as she goes back to her group on this one?
Mr. Chairman.
Yes, Commissioner Flanagan.
I'd like to preface it by saying I'd be happy to work with Commissioner Title and her writing team if she feels it's necessary. My concern with proof of hardship when it comes to Social Security is that it may not be the only source of income that somebody has. Once you hit that age and you're eligible for Social Security, you're allowed to collect and work a part-time job or whatever. So it doesn't necessarily determine need. Also, at the same time, I think that I can understand why there's an inconsistency in how people prove that they have a hardship, right? I mean, we talked about this a little bit in my group with one of the issues that we had with discount programs and who do you give them to and how does it work and what discount is being offered. My goal in all this, and I'm hoping that when the public comments, they'll be able to offer their input as well, is to provide those who are in need with this program. And I truly want them to be in need. So that I think it's sort of a judgment call of us determining what percentage of the poverty level they're at, and also what forms of documentation. There are many people that have Mass Health as a secondary, insurance, or they're getting it for some other reason that may not necessarily be as in need as other people. And I'm not trying to take it away from those who are using the program who may not qualify under certain circumstances. I just think if we're going to have this program in place, then we need to really try to find a rock solid way of determining that need and then proving that need. Unfortunately, I mean, on the surface, I think W-2s are the way to go because it provides your income. And if we're looking at a percentage of the poverty level, then income verification is how that's going to happen. Other than that, there's a whole host of reasons why people are on different programs. And I really would hate to see us get into a trap of just giving people who may not need this program the same benefit as those who truly do. So, I have a couple of concerns about that. And that just comes from my history of working on issues in government and trying to provide programs to people who truly need it versus people who would take advantage of it.
Commissioner Title? I
would welcome and appreciate your collaboration on this, Commissioner Flanagan. I think we're all on the same page. The income hardship is set, and we want to make sure that we are just offering patients a way to provide documentation that doesn't put additional hardship on them. But of course, obviously, we don't want to include people who have other forms of income, or are on Social Security, but they're not necessarily at this level of income. So I think we can work together to make sure that there is a consistent way to outline what proper documentation is, and we could certainly flesh out in guidance how some of this documentation should be used if that's appropriate.
Great.
Absolutely.
Commissioner McBride, any comments?
Have we given any thought to bringing the determination for purposes of hardship in-house into the commission and enabling us to make a determination that might allow for patients to, I think, more uniformly maybe move forward with taking advantage of a hardship program? And also, I get a little, I just get a little nervous about providing a lot of documentation to businesses for a lot of different reasons. And I think that I probably am not alone, and that maybe makes other people, maybe makes some patients uncomfortable as well. I just wonder if there's a way for us to create a more standard way of determining qualification for hardship, maybe even determining different levels of, where people are in terms of the need for it, and sort of actually building a program that functions on behalf of patients in a way that, takes into consideration, some more maybe specific considerations that are relevant to them.
Mr. Executive Director, you have any thoughts on that?
I may. As you know, previous to the transition we made on the patient portal to bring that into our Mass CIP environment, we were previously reviewing, for the purposes of fee waivers, some information relative to Mass Health or other eligibility. So it's not without a history there. It would require probably some additional resources on our end, whether it be for staff or developing more technology around how to indicate it on a patient's registration. So for instance, if they were to present at a dispensary and the dispensary could then verify that they have been deemed eligible or qualified for financial hardship. So we could certainly give it some thought to bringing in-house. I would just caution that it would definitely require a devotion of resources and time. And I'd want to also differentiate it from our initial review of their registration, given that that's automated largely at this point. We want to make sure we can preserve that for just expediency, but then devote the resources required on the verification side. But it's absolutely possible, yes.
Okay, thank you. Commissioner Tyler, you're smiling.
Oh, I like the ideas. I think they're great ideas. I think that if we could bring it in-house, that would probably be very helpful for patients and for consistency. Maybe Commissioner Flanagan and I can continue to discuss that as well with the relevant staff and with patients.
Okay, and you feel like you can turn this around in kind of the timeline we're looking for to be able to have a discussion and a vote on draft regs in the early part of July, second or third week of July?
Yeah.
Good, thank you. Commissioner McBride, did you have other comments? No, okay. Then Commissioner Tyler, if we could move on to topic 17, the last topic.
The topic I forgot about.
Topic you forgot about. I hope it was because you didn't, it wasn't because you didn't want to talk about it, since you volunteered to do so.
This is one that it was also not assigned to a group, but it just.
Can we get the next slide, please?
Thank you. So this was not assigned to a group, but this came to mind when we were having some of the discussions about workers, and especially the recent discussions about making sure workers know that they can make complaints to us directly. So that is why I'm suggesting that as part of the personnel records that are required under our regulations under record keeping, Currently, it just says personnel policies and procedures, and that would include everything that's legally required. The proposal is to add, including at a minimum the following: code of ethics and a whistleblower policy. And I am not stuck to those terms. A code of compliance might be more appropriate than code of ethics. But the intention here is that if there is a worker who has a concern, the code of ethics would lay out for them how to make a complaint, and then the whistleblower policy would make it clear that they are protected if they make a complaint, say, to us or elsewhere, because I think it's not very clear to workers at all what their protections are from retaliation.
Thank you. Can I get comments from Commissioners Flanagan and McBride?
I support this.
Commissioner Flanagan, thank you. Commissioner Flanagan?
I don't really have an opinion either way.
Okay, thank you. I support this as well, Commissioner Title. So if that's the direction your working group requires, I think go ahead and draft language around this, and we'll discuss and debate and vote on it as part of our draft regulations. Do you have what you need, Commissioner Title?
Yes, thank you.
Great. Okay, thank you. So we are now done with the 17 topics that were raised by one or more of the writing teams. But I should have said this at the beginning of the meeting. I apologize for skipping this over. I did want to give the opportunity to each commissioner to put any additional topics that they think need to be on the table for discussion by the commission, with the understanding that we've got to make sure that if it's a new topic that we've got the bandwidth and the time to do the work, get the regulations drafted, and get them circulated to the commission ahead of time so that we can include them in our discussion of draft regulations and our vote on draft regulations. But I did want to give each of the commissioners the opportunity to raise additional issues if they had them. I know Commissioner McBride, you raised one, so let me ask you to start first. Good.
Mr. Chair, I'm actually going to take it off because I don't think that it's something that needs to be discussed at this point in time. I think it's a fairly minor issue and something that can be addressed through the normal public comment period.
Okay, thank you. Anything? But do you have any other issues, Commissioner McBride, that you would like to put on the table now?
I do not.
Okay, Commissioner Title?
No, thank you.
Commissioner Flanagan?
No, the topics that I worked on will be brought up when the regulations are presented.
Okay. I am about to ask for an adjournment, but before I do, and before I put up the schedule of our future meetings, are there any other topics that I was unaware of that any of the commissioners would like to raise before we move for an adjournment? Then can we put up the slide, please, with the next meeting dates, please, Erica? So the June 25th, 2020 meeting date was a tentative meeting date that we were holding on our calendars in case we did not get done with our entire agenda today. We have gotten done with our entire agenda today, so the June 25th, 2020 meeting will not happen, which means that our next meeting is our regularly monthly scheduled meeting on July 9th, 2020. Again, it will be done via Microsoft Teams Live. There being no further business before the commission, may I ask for a motion to adjourn?
So moved.
So moved.
I'm sorry, I didn't hear that. Was that Commissioner McBride? Okay, Commissioner Flanagan always does it, but I don't know if you won this time. Who made the motion? I'm sorry.
Sorry, Flanagan.
Oh, I'm all good with that.
Can I have a second, please?
Second.
Let the record show Commissioner McBride made the motion to adjourn, seconded by Commissioner Flanagan. Commissioner Flanagan, your vote?
Aye.
Commissioner McBride?
Aye.
Commissioner Title?
Aye.
Commissioner Hoffman, aye. We are adjourned as of 2:07 p.m. on the 19th of June, 2020. Everybody have a good weekend and please be safe.
Thank you.
Thank you.